ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಾ ಸರ್, ಅದು ನಿನ್ನೆ ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಇಂಟ್ರಿ ಮಾಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ. ಅವ್ರು ರೆಸ್ಪಾಂಡ್ ಅವ್ರು ಟೈಮ್ ತಗೊಂಡಿದ್ರು, ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ ಅಂತ.
15 ಅಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 50.
ನಿನ್ನೆ ನೀವ್ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಬೇಕಾಯ್ತಲ್ಲ. ಇಲ್ಲ ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್
ಏನಿಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲ ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ
ಹಾ ಸರ್.
ನೋಡಿ. 50 ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ, ಹೋಗಿ.
ಹೌದಾ? ಯಾಕಂದ್ರೆ ಆರ್ಡರ್ ಎಲ್ಲೂ ಅಪ್ಡೇಟ್ ಇರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಒಂದ್ಸತಿ
ಅಪ್ಡೇಟ್
ವೆರಿಫೈ ಮಾಡ್ಕೊಳ್ಳೋಣ ಅಂತ.
ಇವಾಗ ಆಗತ್ತೆ ನೋಡಿ.
ಓಕೆ ಸರ್,
ಈಗ
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್
ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಾವು. ಅಲ್ವಾ ಮೇಡಮ್? ಹೌದಾ?
ಏನಾದ್ರು ಇದ್ದ ಕೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ ಅಂದ್ರೆ
ಆರ್ಡರ್ ಶೀಟೇ ಕೊಡಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ ಶೀಟೇ ಇಲ್ಲ. ಒಂಥರ ಒಳ್ಳೇದು.
ಕೇಳಲ್ಲ, ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೇಳಲ್ಲ.
ಇದು ನಾನು ನೋಡ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ, ಯಾಕಂದ್ರೆ ಕೇಳಲ್ಲ ಅಂತೇನಿಲ್ಲ. ನೋಡಿ, ನಾನು ಇದನ್ನೆಲ್ಲ ನೀಟಾಗಿ ಇದೆಲ್ಲ ಮಾಡಿ, ನನಗೆ ಹಿಂಗೆಲ್ಲ ಇದ್ರೆ ಒಂಥರ ಮನ್ಸು ಸಮಾಧಾನ ಆಗಲ್ಲ. ಫೈಲ್ಸ್ ಎಷ್ಟು ನೀಟಾಗಿ ಇಡಬೇಕಲ್ವಾ ಬ್ರಾಂಚರು. ಹ್ಮ್
ಕೆಲ್ಸಾಕಿಸಿ ಕೊಟ್ಟಿದ್ರು.
ಹ್ಮ್ ಹ್ಮ್
ಹಾ, ಹಾ. ಯಾರಾದ್ರೂ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದಾರೆ. ಯಾರಾದ್ರೂ ಲೋಕೇಶ್ ಫೇಸ್
ನೆಗ್ಲೆಕ್ಟ್ ಮಾತಾಡಿದ್ರೆ ಎಲ್ಲರೂ ಸಿಮಿಲರ್
ಯಾರು ಗೊತ್ತಾ? ಕೃಷ್ಣಮೂರ್ತಿ ಅವರು ಬರ್ತಾರಲ್ಲ.
ಯಾರೋ ಒಬ್ರು ಬರ್ತಾರೆ, ಅದು ಬರಬೇಕು.
ಮಂಗಳೂರು ಅವರು ಆ ಕಡೆ ಇದ್ದಾರೆ.
ಪ್ರಿಂಟರ್ ಒಂದು ಇದು ಮಾಡ್ತೀನಿ ಸರ್ ಸ್ವಲ್ಪ.
ಅದಕ್ಕೆ ನಾನು ತಕ್ಷಣಕ್ಕೆ
ಈ ಪ್ರಿಂಟರ್ ಈ ಕಡೆ ಬರಂಗ್ ಮಾಡಿ ಸ್ವಲ್ಪ. ಇಲ್ಲಿಂದ ಬರಂಗೆ
ಇದ್ರಿಲ್ಲ.
ಸಿಮಿಲರ್ ಆಗಿದೆ.
ಮಾಡಿದ್ರೆ ಇವಾಗ್ಲೇನೆ ಕಾಪಿ
ಹಾ ಸರಿ, ಬರ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ, ಈಸಿ ಆಗುತ್ತೆ.
ಆ ಕಡೆಯಿಂದ ನೋಡ್ಬಿಡ್ಲ ನಾನು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ. ನಿಮ್ ಕಾಫಿ ಬರಿಲ್ಲ, ನನ್ ಕಾಫಿ
ನಿಮ್ಮಲ್ಲೇ ಬರ್ಬೇಕು, ಆಗ ನನಗೆ ಈಸಿ ಆಗುತ್ತೆ. ಅದು ದೊಡ್ಡ ದೊಡ್ಡ ಬಂಡ್ಲೆ ಐತಲ್ಲ, ಯಾವ್ದದು? ಎಲ್ಲ ಎರಡು ಸೈಡ್ ಆ ಕಡೆ ಹಾಕು. ಜಾಸ್ತಿ ಕಾಣ್ತದೆ. ಸೈಡ್ ಇತ್ತು. ಅಯ್ಯೋ ಜಾಸ್ತಿ ಇದೆ. ಸಾಕಷ್ಟು ಬೇಡ, ಅದು ಹಿಂಗೆ ಇರ್ಲಿ, ಸಾಹೇಬ್ರಿಗೆ ಮಾತ್ರ ಇರ್ಲಿ. ಇದು ಟೇಪ್ ಹಾಕ್ಬೇಕಂತ ಸಾಹೇಬ್ರಿಗೆ.
ಏನಿದು ಡಿಸ್ಪೋಸ್ ಆಗತ್ತಾ?
ಆಗಲ್ಲ. ಹೌದು, ಇಲ್ಲ ಆಗಲ್ಲ.
ಯಾರೋ ತಗೊಂಡೋರು ಬಂಪರ್ ಇದೆ. ಯಾರೋ ಅಷ್ಟೇ ತಗೋತಾರೆ ಅವರು.
ಇಲ್ಲ, ನಮಗ್ ಬರಲ್ಲ.
ಇದೊಂದೇ ಇಟ್ಕೊಂಡು
ಇಲ್ಲ, ಮಾಡಕ್ ರೆಡಿ ಮಾಡಿದ್ರು. ಅವ್ರು ರೆಡಿ ಇದ್ರು, ಅವ್ರು ರೆಡಿ ಇಲ್ವಲ್ಲ.
Yes, those memos for tomorrow, this week, those memos for tomorrow and end of the list, please wait till the end. The other memos can be given, dates will be allowed. Yes. Tomorrow. Give an advance copy on Pawan Kumar. Tomorrow. Tomorrow. But why do you move it only today? But you not move it in advance. No, at least tomorrow we'll have it. Tomorrow. Tomorrow. On the just wait, just wait. Okay, tomorrow. Huh? What? End of the list. Wait, just wait.
Demolition of residential complex. The order of the confirmation possible by the group president has been confirmed by the commission.
Tomorrow. 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 End of the list. Yes. This number? ಇಟ್ಕೊಂಡಿರ give it tomorrow.
This one, page number 1, 1 to 5. Page number 2, 6 to 13. Page number 3, 14 to 24. Page number 4, 25 to 33.
25. You have informed the other side. The matter. Week after next step request. Because of this, what this is regarding illegal construction by the other side. Then why you are taking time? We'll dispose it off if he has instruction. You are there, no? I'll give you relief. Why you want to adjourn? Huh? ಯಾವಾಗ್ಲೂ ಜಡ್ಜು ಕೊಡ್ತೀನಿ ಅಂದ್ಮೇಲೆ ಹೆಸಿಟೇಟ್ ಮಾಡಬಾರ್ದು. ನೆಕ್ಸ್ಟ್
Page number 5, 35 to 40. Page number 6, page number 41 to 45. Page number 7, 46 to 50. Page number 8, page number 51 to 54. Page number 9, 55 to 59.
which means have you informed them? Have you informed the other side? You have to inform in advance. You are only for the impleading applicants. And then you wait. Huh? First list the matter week after next. Inform the other side and then you have to inform the court officer. If they object, then I'll take it up. Interim order earlier granted is extended till the next.
Page number 10, serial number 60 to 64. Page number 11, 65 to 70. Page number 12, 71 to 75. Page number 13, 76 to 80. Page number 14, 81 to 84.
51.
Yes.
Yes.
You have informed the other side. List the matter week after next. But you have to inform the other side. Interim order earlier granted is extended till the next day.
Page number 15, 85 to 93. Page number 16, 94 to 98. 52. Page number 1, serial number 1. 63 amendments. Page number 1, 1 to 3.
3.2. 3.2. We delinked and listed separately next week. Interim order earlier granted is extended till the next day.
Page number 2, serial number 4 to 7.
The matter week after next. Interim order earlier granted is extended till the next day.
Page number 3, 8 to 11. Page number 4, 12 to 14. Page number 5, 15 to 18.
What has happened? Huh? What notice? What is it? Huh. Tomorrow we'll have it. What will happen? We'll have it tomorrow. Give him a copy. Let us see. When it reaches, we'll list it. These are the batch matters. Batch matters, ground rent. Let us see. Tomorrow. There is a list along with UP 181. Yes. Adjournment. Copy.
From 2008-9 onward, they demanded this. Then he sought a clarification of what means are you dealing this. They self-employed a reply after 4 years. Please come to the page 100. In 2020, you know, immediately wrote a letter. That letter is at page DDSP. Come to this. My lord gets out in the beginning. 8 and 12. 130. Please come to the first one. Waiting area. They charge at the rate of 8 rupees. And I pursue the last 800.
Then
14, 114. I got 116. For ITB companies, industrial buildings. That's what you find about owner and the middle. Category number 14. 4 rupees. Giving paying at that date not promptly, no difficulty about it. That's not what they do is. Because
The category 14 is what is applicable?
Asking industry. What are those?
Yes.
Please come to the third page. Industries. Last scale industry is not four rules. We are the last scale industries. They got for 16 numbers. I not say that at any page. Other what is 16 only it was increased to not. That can be done. Why this is not? We were one penny. Why this is not? Even that part we get five. They we will not file an appeal because the notice said within 30 days you file the objection to the commission. You file objection. What they do is they will not keep it not pending for about 4 years. And 2024 suddenly you got the engagement notice. Demand people it is something like running pay 100 150 50. Only 2008 to 2018. 2008 9 to 2018. 2008 9 to 2023. In fact, if you certificate the difference amount and the my lot got that difference amount 1, 2, 3, 4, 4, 7 crores got according to them is the difference. What happened was in the middle got we under protest got just got to because they started harassing us. We paid got my lot some got only paid. 108. We paid 3.8 crores, 3.258 crores. And it's just 8 crores. My lot seems to not be paid from second time. EDs were not dated 96. They returned it in 2021 saying that we are validated. Not got that one. One is one check for 1.64 crores, another for 1.74 crores. Total lot aggregates were nearly about 130.5. They will not ask us to revalidate, we revalidate and do it next day. Submitted, revalidated it and submitted it. So there are 3.5 crores. Even though we are not liable. Then will not be another harassment. We paid about 1.87 crores and 310. So not totally. Even though we are not liable, 5 crores will is in the kitty. 5.26. Now not if you are not discount to running page to 50.
No, all this was paid during the pendency of the appeal.
8 crores. Okay, well, 7 crores is the difference. In fact, what I can submit your lot. We paid at the rate of 4 rupees in 2016 at the rate of 5 rupees from 2016. Nothing not one penny for this.
Relying on some circular.
Circular. Lots may come to the circular, which might not get that as not running page. It will not page 53. 52 was there. Come to not 52. What? Last paragraph. ಆದ್ದರಿಂದ ಕಾರ್ಕಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯ ಸ್ವತ್ತುಗಳಿಗೆ ಅವಾನಿ ಅಂತ ಹೆಸರನ್ನ ಏರ್ಪಡಿಸಿದೆ. ಎಸ್ಕಲೇಟ್ ಹೊಂದಿರುವ ಕಟ್ಟಡಗಳಿಗೆ ದಿನಾಂಕ 2/12/2018 ಪಡಿಸಲಾದ ಅಧಿಸೂಚನೆ ಕೂಲಿ ಆಸ್ಪತ್ರೆಗೆ ಧನವನ್ನು ಪುನರ್ ನಿಗದಿಸಿ ವರ್ಗ 14ರಲ್ಲಿ ಪ್ರಮಾಣ ಕೈಗಾರಿಕೆಗಳನ್ನು ಪರಿಗಣಿಸಿ ಆದ್ಯತೆಗೆ ಪಾಲಿಸುತ್ತದೆ. If you are not come to that notification 2016 notification. Now, please come to page 135. This is not a circular issued by the commissioner. What is published in the Gazette? Comment page 135. This is what horizontal two like that 2016. What? 6 of the all non-residential use of property provided industrial areas, etc. Biotechnology firms not falling under category 7 and 8, including building provided with some. So, if I fall under class 12, then I am not able to do this. It's a similar impact. It can come down. Lastly, example, industrial units with the defined in the telecast set up by the industry, they have, but including all building provided with escalator. Category 6. Category 6 only, they exclude class 12. Category 12. We are in category 12 in 2016 and they were
No, this was during the pendency of your appeal.
Yeah, okay, 2016 and earlier. What is part of 2018? And we are given up to 23, according to the word 7 crores. And paid to lot 5 crores, 28 crores, 5.28 crores, even though I am not able to get a protest.
Hear it. They hear it. With them, they have crossed the appeal stage. Correct. What they're saying is also that for the years which was an issue in the appeal, you have made use of that circular and revised it. So whether what was first declared in terms of it, how the circular operates, the matters will look in. Correct. So that was the change. That was the change that was brought up by a circular of amending and substituting. Let's see. We'll examine. They've revalidated and submitted. They've revalidated. Revalidated and submitted. Time, BBMP must be little professional. Now there's no point in saying yes, we are going to initiate disciplinary proceedings because there are lax in revenue collection. All those properties outside the tax net, zero tolerance. You have to identify many of them. Some person had filed for 4 years, he has not paid tax. So he said they didn't come to collect. That's no, those outside the tax net. First, they have to concentrate, and then you must come and do it professionally. That's all. Submitted that during the pendency of the appeal proceedings, without prejudice to the contentions raised, an amount of 5.26 crores, 5 crore 26 lakhs 3,641 has been paid. Light of the contentions raised, including regarding the circular, enhancing the, including the circular, clarifying the applicable category. Subject to further consideration, there would be stay of the order. And the demand notice at A1. The respondents to file the statement of objections within 3 weeks. Kumar accepts notice for response 1 to 3. This is the matter thereafter. Give him a copy. There will be a page 18. There will be an inspection. You have paid up to date tax, yes, according to whatever you have been paying. You have paid up to date. Same order has been Form A. Inspection on 4th of March. At 11:30 AM. Respondent BBMP not to take precipitative steps pursuant to just one, include notices and orders. We stay of the order at annexure C in the next week. The ground rent. Demand notice at annexure. Annexure E is the notice. We are seeking stay of which item? Ground rent of 63,02,500. Item one. Ground rent, 63,02,500. And this is your plan is still pending consideration. Occupancy certificate. So occupancy certificate must be considered upon stay of this. That's your interim rule. Don't give him a copy. Give him. Showcase notice they are not, is not there. You will you produce it. We'll have it in the orders list next week. Same.
Asking them, not the problem. Only not available in the standard. Not the problem.
We'll consider that. It should be. It should be. Let him produce a show cause notice. Let us see. The respondent will to not to take precipitative steps pursuant to the inclusion of the orders and notices at annexure E and E1. Matter the next week. It's the matter in the orders list next week. You produce the show cause.
Serial number 23. Different year, 2018.
The
23.
mention that certified copy will be produced in due course.
Visible. Okay.
Objection, there is permission of 3 copies. It's kept open support undertaking that legible copy will be furnished at the time of hearing of that we relied upon. This is the same.
Same property, different year. Because 2018, serial number 5 is shown because year 2016.
Same annexures.
Same.
Give him a copy.
Number 6. Number 6.
Where we adding on the poultry mating. Laying the mark on parts only, it is all laying it. And the tractor is on it. And so many notice that they came and filled it, it's not okay. That I don't want to take the page number 1. Order attachment is number 1. Does not provide us the I thought you would any of the alpha demand.
Focus no. Make some deposit that will be adjusted only to the lawfully determined tax. How much you'll deposit? Correct. Now, property tax is okay. Property tax is 1,60,940. Property tax is only 1,60,940. So you make some deposit. How much time? How much time? Huh? You find out because Mohan is not paying, his client is paying. Huh? How much time? 3 weeks. You have to file an affidavit within 3 days. Okay. The same form as further it is submitted that there will be sealing of the premises. Or else the undertaking of the petitioner to pay the property difference in property tax indicated with an HSC of 1,60,940. Such submission within a period of 3 weeks is taken note of. Affidavit to be filed within 3 days. Affidavit to that effect. Accordingly, BPMP is restrained from taking any precipitative steps pursuant to Annexure D1 to D7. There will be a stay of the order at Annexure C. The respondent BPMP to deseal the premises forthwith. Such order is passed after taking note of the undertaking of the petitioner to pay the difference in tax of 1,60,940 within a period of 3 weeks from today. It's made clear that in the event of not complying with the undertaking, the interim order would stand vacated without reference to the court. AG is directed to accept notice for respondent 1, Pawan Kumar for respondent 2 and 3. This is the matter in the orders list. This is the matter week after next. No, in orders list next week. Yes, yes. In all these matters, you give him a copy. In all these matters, there's a variance. The measurement and what is, let there be an inspection. Same order, is it E? Or do you increase the strength of taking these steps pursuant to the impugned notices and order? Inspection on 4th, on 4th of March. Petitioner to be present along with the tenants. 4th of March at 11:30.
Four properties are.
Sentence dealing with or name should delete. We uploaded it. We uploaded to it. That's it's school one. Let it will bit along with that. Now they are insisting without prejudice to your rights. In the matter is pending, you can, if you are not sought for exemption, as a matter of abundant caution, you seek, because they are insisting that separate application will be made for exemption. That legally we'll see later. Without prejudice to it, by the time it comes for hearing, let us. Huh? Okay, but where is that? It has to be only. Huh?
Where they say under 110 months I am exempted from 1/4/2008 Vinayaki Nidara. In spite of it, now the demand notice it becomes the 23 from 2008 onwards.
Section G. Then, if you are insisting, you better make some public notice. Forget about his case. In some other, we are taking the legal contention that every year they have to apply. Then you either make rule or you make a public notice. So let the people be aware of what stand you take. Light of NHG, in light of the certificate at NHG, and in light of the contention that the petitioner is exempt from payment of property tax in terms of 152(1) Roman 1B of the BBMP Act 2020, there would be an interim order of stay of the demand notice at annexure H. Now list the matter along with WP number. One, just wait. You have the file. So construction is in which year? Only on that ground. Construction is completed. Give him a copy if you have extra. The whole case is construction is completed in 2004. And representation is made by a person who has some case with them recently. Construction is completed then itself. So after this, the plan is at page 28, isn't it? It's a D. Huh? Huh. So after that, you have not put up any construction. That was the last. Bit of the contention. Petitioner. After obtaining plan on 16/5/2003 at Annexure D, construction was completed by the year 2004 and no additional construction is put up thereafter. Accordingly, it is submitted that power under the statute must be exercised within a reasonable period of time, and if the construction was completed in 2004, the complaint by a person having a running a litigation with the petitioner. No, correct. He has a litigation with you. At the instance of a litigant who has a case along with the management of the petitioner, which has been made only in the year 23. He has made the complaint in 23. In the year 23. On? On 20. Which?
Third party was nothing.
But in the instance of that other person, 24 cannot be acted upon.
The complaint at the instance of a litigant who has a case along with the management of the petitioner, which has been made only in the year 2024, cannot be acted upon.
To a third party. Taking note of such contention. Power cannot be exercised after an unreasonable period of time, insofar as construction completed in the year 2004. There will be an interim order of stay of annexure. And proceedings there. Now, this is only for that purpose. The notice is only for that purpose. That there is something, anyhow, will accepts notice. Respondents.
So I think that will be addressed now and the DMP says that it is presented or because that is fine. I replied to the super notice saying that I've been in the provision for the last 38 years. In self-occupation, there is no agency. Yet demand notice is available.
Let there be an inspection. Same order. On inspection on 4th of March at 11:30 AM. In the interim, respondent will be to take steps. Respective steps pursuant to the informed notices and orders. Yes. Each time granted for necessary compliance. Yes, next.
Number 15.
Time granted for necessary compliance. Next.
18. Yeah, 15.
Hmm. What is the main matter? Allotment of? Hmm. Not paid. I'll pass over, bring Vivekanand. Pass over. Bring him, pass over.
17.
Yes, yes. After 2 weeks at request, petitions to be complied with in the program.
18. 18.
Order.
19. 18.
Same order.
19.
Yeah. Petitioner has filed a memo which reads as follows. In light of the same, petition is dismissed as withdrawn. Liberty sought for is reserved. A registry to return all the certified and original copies filed along with the petition. Next year. But go to page 22. Correct, but you have declared it as self, is it? Go to page 22. Huh? You come down there. The change in category also. There is a non-residential with escalators. Right? Let there be a spot inspection and a hearing. Order as
Connection.
and contents as Perusal as a show cause notice. Okay. But there is also a divergence regarding the applicable category. The report as directed to be filed by the BBMP is to advert with respect to the said aspect also. See. Responded. BBMP restrained from taking any precipitative action pursuant to the show cause notice section D1 to D15 and E1 to E2. Was fine, stating that orders have been passed, copies of which are enclosed. Respondent BBMP is also restrained from taking any action pursuant to the said orders in order to which may be taken to enforce such orders. Inspection on 4th of March at 11:30 a.m. It will be uploaded. Yes. Yes. What do you want? Objections. Give him a copy. Just give your copy for me. Page 15. Let there be an page 15. Let there be an inspection. Huh? Huh. Let there be an inspection. You have paid up-to-date taxes. Till latest you have paid. In order to inform you. No question of tenants here. Tenants and the bedroom. Tenants and the bedroom. Notice that divergence also as regards to the applicable category. For the BBMP to advert to the same. Inspection on 4th February at at 11:30 a.m. Upon the VP undertaken with respective steps pursuant to the impugned notices and orders. Then next date. Office objections to be complied with in the forthwith. Must comply forthwith. Panchayat has just adjust the mic.
Now, this design issue came up for consideration. Because that in one of the developments of the class I should have taken a view. This very exhibition and then before after long lapse of time may not be possible. Rule 5 and Rule 7 of the Panchayat barrier rules of Tamil Nadu was the value for interpretation. Which is very media with sections 95, 92, and 95. To 95 and 95, 92 to 96 of the Act. It's with the manner in which the Panchayat was required to regulate the barrier. Similar problems came up for consideration. And the Panchayat was of the view that in such circumstances, the only direction that can be issued is to exhume the body and then locate the bodies to the designated place. Because so to see from page number, paragraph number 19 of notice. Up to paragraph number 18 notes is extracting the arguments of the notes. Paragraph 19 onwards.
Read.
None of the elements cited on the either side, including Swami's case, say it is an absolute right to bury a body in a place other than the designated place. It is legally permissible. For specific reasons stated in those cases, courts have denied execution of body. Otherwise, in any court, courts have held that Rule 4, 5, 7 of the Tamil Nadu Panchayat barrier rules 99 go not explicitly to the burying of non-designated place. Implicitly restriction the conditions provided such barrier. Even if anybody wishes to bury a body in a non-designated place, you shall only have to compliance with Rule 5 and not otherwise. Rule 4 in respect of the places used as a place for burying or burning of the dead. Prior to the act and rules given to it's mandatory for the owner of the land to register with the Panchayat. If no owner or person having control of such place makes an application, then less than itself shall assume control or register such place, or may with the sanction of the Assistant Director of Panchayat closing. As rightly claimed by so and so, the council could have in the case where the body of so and so was buried on 2423 is not a case of burial already registered to the Panchayat. Till date, the person who owns the land and controls the land, Shanta has not given any request for registering the places of burial ground. In fact, it is a condition that burying one forms of private land will not make the land a burial ground. This court reminded of the saying, single swallow will not make it summer, but then only swallows will make it summer. The heading for Rule 5, conditions for opening a burial and burning ground is relied upon by so to say that place a single body buried is different from burial ground. Rule 5 and Rule 5 is extracted because I skip this and I come to section 92 and onwards I read it once again. The contention of so to the applicant is that burying of so and so owned by Shanta is not tangible to opening of a new burial. Stipulates condition imposed on Rule 5 to be satisfied. The argument is not sustainable. Interpretation of the rule is to be from the words implied in the provision.
Heading to the chapter or a provision in the chapter may lead to a provision but not to provision. The provision is unambiguous, the heading cannot be used to refer to anything but to provision. In zones of expecting the provisions of 5 and 7, this word declined to examine the top buried in the playground school, stating that if it's reasoning that tops only buried cannot be removed, at the juncture because the patient stepped over the matter for more than a year, woke up only after the burial of the poor Muslim's life. He succeeded them by allowing the corpse to remain in place where it's buried and had imposed the condition. Responding to burying the bodies is an unauthorized case directed the district director to protect the property from burying dead bodies in future. Other cases of an identity issue came up before the and has been buried also not true. You know, private land can be converted into a burial ground without license to local panchayat. And the procedure prescribed with the Tamil Nadu rules for using land as a burial ground, previously without following the same procedure without converting the land into a burial ground without the license of the panchayat, the burial appears to have taken place. Therefore, the petition is entitled to release or sought for. However, the execution of the dead body of the person for purpose of burying is elsewhere is a matter connected to previous other significant parties. Unfortunately, the system is not easy to appear before me. That is the petition. Therefore, the only alternative available for peace directive does not notify to give office if it wants to do it itself, so that the sentiments of respect are not offended. During the pandemic, so and so, right due to COVID-19 infection, corporation in charge of the body buried so and so. His wife so and so approached the court and matters directly to corporate authorities to make necessary arrangements to exhume the body of so and so from so and so. The selected of this court allowed the petitioner directed the court to spot the corporation to exhume the body of silent activists and revive the same in chief of secretary after following WHO protocol 19 issued by the state and central government from time to time. The same law of exhumation came to be passed more than a year after the burial. In Matthew of the state of Kerala, reported in 22 Kerala, burial of a body in a non-designated place came to be tested in the light of the rules made by the Kerala government for buried and buried dead bodies. That case, the district can actually go to landowner, but prepare a group for people to be buried after the directly into get the same incident that the Kerala actually said what is was then stating that the Kerala last burial ground books is not applicable to the case various something. It could be interesting to be in future. The state cannot impose restriction on the conservation of the own body and own property where it is setting the state to the Kerala stating that the rule prohibits only constructing by using any new burial ground without license. When we look at Rule 7, one of the Tamil Nadu Panchayat rules, we find that it's analogous to Kerala rules of 5 the way it should be. Both 5 and 7 of the Tamil Nadu Panchayat provision for burial and burying rules 99 started negative clause. Rule 5 prohibits no place for burying or burying dead or license to trade to the left child. Rule 7 prohibits burying or burying any corpse any place with 90 rupees. This also against license burial and burying ground is example. Rule 5 does not indicate the place where a body is buried or burned will not carry the tag of the burial ground or burying ground. Single body is burnt or buried, and the landowner has the intention to allow burial in future. However, whoever people case, whether private or public, to be used for burying or burying the dead, the license is used. Thus, it is very clear that except the case is only be registered on the rule. Following cases where the license is obtained following the procedure certificated under Rule 5.4. Nobody can be buried or burned in the place.
No body.
No body can be buried. That part is places which are provided with the license in the 3-5. Framers of the rules for purchase of the fact that there may be violation of Rule 7. Therefore, those prescribed punishment in contravention of 7. But prosecution can be instituted only on written sanctions and excluded on the relation to that. The outcome of the above analysis in the rules the case does lead to the conclusion. The condition of 90 minutes restriction found in 7 cannot be considered as right to bury body anywhere and everywhere. Burying or burying body is subject to other rules, conditions of distance restriction from one body cannot be read in education. Unmindful of the purpose of the rules in other policies calendar. Division bench in Muthuswami's case had not declared that the body can be buried anywhere other than this the license space in the village panchayat. Division bench would be recognized the custom prevailing in that particular village. Observation made in Muthuswami's case is restricted only to the facts of that case. And have no application in that. Moreover, after the rules of 1974, any burial in the place other than the place only registered or licensed to burial ground goes in contravention of Rule 7. Any body buried in contravention of 5-7 needs to be exhumed and buried in the designated place. If such violation is brought to the notice within a reasonable time and despite notice to exhume the body,
or to be buried and treated is not identical with the person concerned. Bodies to be exhumed by the authority and collect the cost from the person who is the cause of that illegal burial. The exhumed body must be buried in a designated place, taking into consideration the public health. Person who defies the law and refuses to exhume the body cannot take umbrage with the delay, now controls with the law and make court create a body. According to the reference and answer to the your Lordship, so this is section 92 of norms of the Panchayat Law.
So now you make that upgraded. Which is the,
Now that it is informed.
which is the entity? Which is the entity? Which municipality? No, no. Who is to be made as an additional respondent? Punapana Agrahara municipality. And council appearing for the first respondent submits that the Gram Panchayat has been upgraded to a municipality. Right of said submission. Let it be as an additional respondent. So and so is directed to be included as an additional respondent. Now, why don't you make those persons, if you have knowledge of who have buried, as additional respondent? No, reason being that in the event court has to pass it. Let us hear them also. Let us hear. At oral request is made to implead the yes. That will see. The petitioner is permitted to implead the legal representatives of the deceased whose bodies have been buried, who may be necessary parties, while molding appropriate relief the time of disposal of the petition. Learned senior counsel appearing on behalf of the petitioners relied on order passed in WA 1037 of 2023, passed by the High Court of Judicature at Madras, in the case of Jagadishwari versus Babu Naidu and others. It submits that the High Court of Judicature at Madras, considering an identical provision and similar factual metrics, where the body was buried in property belonging to some in a private property, had directed exhumation of the body and passed further direction while noticing the bar of burying bodies in other than notified graveyard, burial ground. The respondents to take their stand as regards such aspect by the next date. The matter, the week commencing from 11th of March. By then you implead. That we'll see. That we'll mold it. We'll see what is to be. Now that newly constituted body, who appears? Will appear. Then, it's the matter. So and so. You serve him a copy. No, now you have the copy. Amended petition to be filed. Yes. Interim order earlier granted is extended to the next day. It's an interesting question. Let us see. Yes.
Treated as part.
Huh? He's tempting me saying that we can treat it as partnered. Matter is treated as a partnered in light of the issue raised. I may appoint an MI to sell. Let me just.
Six.
First, is the matter?
Based the judgment on records, they have questioned two things. Primarily, they question the reservation to the Gram Panchayat Adhyaksha and Upadhyayksha. No interim orders so far, elections were conducted, and first prayer has been used.
Just take me to the prayer.
Law 44 of the
Just take me to the prayer.
well. Initial prayer was assuredly watching the notification dated 21/6/23, issued by respondent number 3 and direct the respondents to redo the allocation of fees in accordance with the guidelines. So this prayer, my lord,
Their challenge is to the roster.
this
Reservation roster.
amendment
No, this is one by one. So this is the first prayer. Now elections have been. This was to the post of Adhyaksha of the Hesgard Gram Panchayat. So that election has been held.
code under which the amended petition.
Section 44. Section 44. Yes.
44 of the Gram Panchayat. The Lord's, their grievance is, the law does not have any restriction for repetition of the same categories. That is their main grievance in the grounds which are raised in the. But similar petition was filed before my lord and questioning section 44. In that, my lord, what had happened is an ST candidate who had lost the seat, I'll face a judgment on the body. Scheduled that he lost the seat for no confidence motion in section 49. And my lord, the reservation is once every 30 months. Now again the election is supposed to be held. The grievance of the petitioners in that petition is, my lord, that same candidates will again get elected because the reservation is for scheduled tribe. So at that point of time, it was questioned that section 44 validity was questioned. My lord, para 2 of the judgment. The contention advanced on behalf of the appellant is that Prabhavati had been elected as Adhyaksha of the Gram Panchayat. She belongs to scheduled tribe. The post of Adhyaksha is reserved for woman ST candidate in terms of the Gram. We now the challenge the validity of this provision that is rendered so let's para 6 and 7. We pointedly ask the learning council for the appellant as to whether there is any provision in the statute barring context for the same office at a later stage. In normal circumstances where there is no reservation, the learned council is not in a position to point out any such prohibition. If in the normal circumstances there is no bar against whom no confidence to contest that vote. Later, and if he is very confident of winning the election race, so why does the person cannot contest the election? Beyond our understanding, and such a stand hardly stands logic. Therefore, we think we should allow the person comments to the respondent to reach its logical end. At the same time, we should also notice the very difficult and impractical results which could lead to which the provisions of enactment are given full effect. Under section 44, certain reservations are given to persons belonging to certain caste or community, and such reservations are considered proper, bearing in mind that such posts were never held by such persons belonging to such caste. History cannot be forgotten in that regard. Reservations made to protect such persons was further provided. No confidence motion could be moved only in certain circumstances, such as disability arising on account of serious misconduct of an incumbent in the office. Otherwise, as the problem stands, the enactment leads to frequent situations such as in the present case, as in a person who has confidence is elected against such office, and such person is not in a position to command majority in the panchayat. There will be a deadlock in the statement in panchayat. The legislature will have to bestow its attention to this aspect and to the rest of the country. Yes, Mr. Ray.
Correct, but whether validity of 44 was mentioned.
Exactly. I said the topics. Virus.
It is. Then you file, take your stand. Let them take their stand.
Now the exact prayer now is there is a perpetual reservation in some of the Gram Panchayat. Perpetually. So perpetually general seats are not considered for. So there are three main prayers. One as far as section 44, either it has to be my lord or that extent my lord, providing a perpetual reservation. It has to be certain or it has to be let down. And also as a legislature, the notification issued by the election commission is concerned. And it has to also provide for the sufficient opportunity for the general seats. That is these are the general prayers, specific prayers my lord made the. That's why I have to submit the Dada Patil rendered in 1996 spirit. Despite this, the legislature has not answered this very on both my lords.
No, the word rotation is not used.
One more important point is that now last the elected governments who is of course to their will after the election resolution. Not the way you have made is this resolution can be announced before the election. What they do is once persons are elected by us, then they go on with the resolution, give some doubt with the elected person that we belong to a rival political party, therefore we have not been elected. Therefore, there should be transparency in this method. Why not before the elections?
That software, even you share it, let them have a look at it. Some software they have designed, which they have placed it before the Supreme Court. But on same lines. Share it with them. Share. The senior counsel appearing for the petitioner responding to the submission of Additional Advocate General regarding the order passed in Bapu Dada Patil versus State of Karnataka submits that despite the observations in para 7, necessary amendment has not been carried out. The respondent state, you have filed your objection. The state AG additional appearing for the state submits insofar as the amended prayer written statement of objections will be filed. Such statement to be filed within 2 weeks. This is the matter thereafter. Yes,
litigation post the election, post the reservation order, that can be
at the last minute also filing, announcing it then there's no opportunity, then it becomes infructuous. It's a cycle.
For the election, these are reservations. Why after the election? The bill is also reserved for that. It's only for the person who is in the dharma capacity can decide. And at least it don't arrive in the electorate. So the also may not to validity to the rule of law. That also be dispelled.
Yes.
Nagarati.
Now with new version, they come into.
But now you point out where is their stand earlier, which gives an impression that they were accepting it. Let us see. Next year? Yes.
ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಹಾರಧನ ನಿವೇಶನ ನೀಡಬೇಕು ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ದಿನಾಂಕ ವಾರ್ಡ್ ನಂಬರ್ 7 ದಕ್ಷಿಣ ಬಡಾವಣೆಯಲ್ಲಿ ಬರುತ್ತದೆ. ಆಸ್ತಿ ಸಂಖ್ಯೆ 1996ರ ನಿವೇಶನ ನಂಬರ್ 21ರ ಆಸ್ತಿಯು ಶ್ರೀ ಎಸ್ ಸ್ವಾಮಿ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ ಮತ್ತು ಅಳತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 16 ದಕ್ಷಿಣ 50 ಪೂರ್ವ 16 ಉತ್ತರ ದಕ್ಷಿಣ 30 ಅಡಿಗಳು ಇರುತ್ತದೆ. ಕಚೇರಿಯ ದಾಖಲಾತಿಗಳಲ್ಲಿ ಸೈಟು ಮತ್ತು ಅರ್ಜಿದಾರರ ದಾಖಲಾತಿಗಳಿಗೂ ಪರಸ್ಪರ ಅಳತೆ ಮಾಡಲಾಗುತ್ತದೆ. ತದನಂತರ ತಾಂತ್ರಿಕ ಶಾಖೆಯ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಿಸಲು ಪರಿಶೀಲಿಸಿ ಸದರಿಯವರಿಗೆ ಸರ್ಕಾರದಲ್ಲಿ ನಿವೇಶನವಿರುವ ಬಗ್ಗೆ ಶಿಫಾರಸು ಮಾಡಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ
Now, the Tata and the sale deed in your name, is it? Where is it? You are buying 20?
28 the schedule modification is being.
So this is purchased from Usha Devi. Huh? Both.
So,
Chanmuga. Chanmuga Swami and Usha Devi. From Basappa. Pata is also joint name, is it?
Then understanding the basic and cash and the need of fund. There was a transfer deed by giving pathway to the yes, giving path. Because I feel that the same. Both was executed by Vendor. They said, my vendor has no right to execute the civil.
It's a matter before the civil court. No, that's a matter for them to go before the civil court. Now, Kata, where is the Kata? The sale deed has not been challenged.
Now we can say.
No, after I'll come to you. Now, after annexure E, what has happened? What is it?
directions from the office of the in spite of direction, they are not failing.
Nature K.
ಇದ್ದಲ್ಲಿ ವಿಶಿಷ್ಟ ಅಭಿಪ್ರಾಯಗಳೊಂದಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವಂತೆಯೂ ಹಾಗೂ ಕೈಗೊಂಡ ಕ್ರಮದ ಬಗ್ಗೆ ಮನವಿ ಸೂಕ್ತ ವಿವರವನ್ನು ನೀಡುವಂತೆ ಕೋರಿದರು.
Now, what is the statement of objections? I'll come to you.
Purchase or transfer deed, he has given some extent to him and some extent to him. Road was quite an investigative. First, they were quite because there was no pathway to enter my scheduled list. For that method, I have taken some extent to the necessary.
You deposit the compensation, we'll hear the money.
What the statement would be.
No, is the road formed or not?
No, Lord, is 1954, Lord.
No. Then you explain initially. E and F you explain. No, that you first go to E and F, we'll go to. You deposit before the court to demonstrate the fact that the road is formed. Okay, then go to E then. First go to E.
And I read these documents and I advised my client to pay. Later, when we found Lord that the road already existed in 1954. Page 10 of the
Page?
Page 10 of the
Yes.
Site was granted in the year 1954. The site was granted in the year 1954. And the original owner divided this site and sold it to 3%. And this was towards right side, towards northern side, it is what road. 40 road is there. So this road they have not touched it. And their land has not been utilized. This road is existed in 1954. Kindly slab, they have not the land for the Page 50.
Page?
Is take the copy. 28/6/1954.
Page? Page?
Page 50. Ulegala form slightly illegal. Around the site was on 28/5/1954. Site is number 21. Yes, it's not any signal. Always. Who was the colony? So there is no. Another friend said there is no place, therefore she has given some place to take the pathway lane. Not correct. Okay, then we not compare this with the mistake that okay, page number 10.
All this now, how can we expect the RIT court to do
But
it?
that's why they have no right. This kid or now, each other go to some competition for the.
Okay, now E and F you explain. Explain E and F.
Yes. And not, but I also saying that I was thinking to like our advice to them become KTC manager 50. Based on the 50. This kind of stuff.
Lecture E, page 27. Hmm. That will come first, you come to E and F.
In fact, I have read before the last thing.
So
And I
how,
wanted time to
how,
give up.
how do you explain that
It's
annexure?
not that Uppers has not even said, Uppers has no right to tell.
No, no, who has given annexure E?
He said, we got the officer and people will not. That is, police will not.
Correct.
There is no.
Have you, just one, have you initiated action against him? You do it, then we'll consider. No, I'm not deciding today. I want you to demonstrate your bona fide by taking action against the person at annexure E. You do it. I'm not. Do it then.
For that.
No, that means, see, I'm not disposing it
No,
out.
guys.
Hmm.
I'm not saying they're not opposing. They're
No, we'll hear it. I'm not now deciding it today. I'm going to adjourn it.
For that, I take page number 15.
No, no, let it come now. We'll see. I don't know whether I'll only be hearing next week. What's the point? Let us see. But what I'm saying, prima facie, if the case that is made out by you, that they don't have title or something like that, that annexure E and F, you will have to, you that. So let them take action against E, a person who is the author of E and F. Page?
First transaction ಒಳ್ಳೆದಾದ meeting on 28/6/1962 the site has been allotted. Kindly without boundaries. ಪೂರ್ವಕ್ಕೆ ಕಾನೂನಿನವರು ಅದರ ಸೇಮ್ ಕೂಡ ರೆಕಾರ್ಡಿಂಗ್ ಪಶ್ಚಿಮಕ್ಕೆ ಬಗೆಹರಿಸಿದಾಗ ಉತ್ತರಕ್ಕೆ ಕಾನೂನು ವ್ಯವಸ್ಥೆ ಮಾರ್ಕ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ದಕ್ಷಿಣಕ್ಕೆ ಮೆಟ್ಟೆಗೌಡ ಸೈಟ್ allotted in the year 19. This Jairam Shetty has sold his site to Ubaya Shetty on 23/8/1960. Second transaction. Then can be similar. He has sold this site into 3 parts. One is Ubaya Shetty. Another is not.
No, but the typed copy says Jairam Shetty has executed sale deed in favor of the society. First entry. Baredu Kottavaru. At serial number 1, Jairam Shetty has executed sale deed in favor of the society.
Well,
Here we correct it. Even the typist is in favor of them. You correct it and file it. Correct it and file it, let us see. But you must demonstrate a bona fide by taking action against the author of E and F. Otherwise, it stands against you. Let us see. The joint of file is taken on record.
their land is not we have to pay. Their land is not paid to utilize.
Let us see, but E and F you must demonstrate.
What is existing before the.
No, correct. But E and F you
You are not like single feet.
let us
Road,
see.
the straight line in the time is not, the straight line is still there today.
Let us see.
The they utilize their land, Road, their line has to come here, this is the right side.
This is the matter, we captain. Yes, next.
I will find it.
This is the matter on 11th. 11th. There'll be some change, so let us see. I'll fix a date, then take it up. In a second.
Respond to this.
Yeah. How many rejoinders? Can
No, they know they have not do the process.
you file? If there's anything, you file. Yes, next.
This property. I attended the grandmother's property. It has come to my father. After that, after the demise of my father, I am in possession of the property. So evidence that
You take out notice. AGM.
same.
You have lost the appeal, let us see. After we'll hear that, I'll keep it open. I'll keep it. No, let us. No, correct. Please. Let us see. We have to hear the other side, then we'll examine. I'll keep it open. Area is directed to accept notice for the first respondent. Executive Officer, Taluk Panchayat, Mulbagal. BJ Somayaji is directed to accept notice for respondents 2 to 4. Emergent notice to the 5th respondent. Consideration of interim prayers kept open. This is the matter. Week after next. What about the office objection? First time it's coming.
The petitioner acquired the property, very fact number for the 10, under the district delegated 21 in 46. The property clearing, the other number 233 and 137. This is at 148 is the schedule. And even I has been affected in the name of the petitioner.
Now what is happening?
The resolution has been passed to the order to be cancelled. The other affected in the name of the under the resolution under the presence of the Adhyaksh of the resolution has been passed. And order to be cancelled. The other affected in the name of the
The Kata earlier was made in which year?
19 of the
It's 19.
page number 12 is in that. Right, sir. The layout form the way is in that.
No, when was the Kata made for the first time in your room?
In the year 1981, the last October. This is a page number 23.
In the Kata, when was it made in your name?
It was inspected at the time of the site. It replaced my land and
Rojam.
the subsequent the Gopalappa Avadi, he executed the deputy in favor of his wife in Malad and the deputy in 2013. And the Kata has been affected in their name. Clear to the Malad, the Kata was affected.
I'm asking you, in favor of the petitioner's name, when was the Kata last transferred?
After the time of the effective Kata,
Where is that? Where is that?
34.
30?
In the year 2013 and 14, the Kata was in the name of
34 is Sarojam.
and they rounded up and the Sarojama name has been.
I'm asking the petitioner.
I have placed the document that it was in the name of Gopalappa. And it was a transaction was taken place in the name of Gopal, the Sarojama, by executing the district deputy.
As of now, you are the owner of the property.
As of now, I am the owner, the petitioners are the child owners in that.
You produce your Khata, let us see.
I will take Nara because of.
When do you want it? When do you want it?
The regulation has been passed in Nara because of the cannot to be and.
I'm going to give you relief. You produce that. You want it tomorrow. If you can get it, you file along with the memo and consider tomorrow. Relist the matter in the same stage on 23rd. You file it, will. I only want to know if there is, if Khata is made in your name long back, you say 10 years or 15 years back, I'll take note of that and then stay then impugn on. Get it. Pass on.
Radha Ramesh.
The residential house in the under Indira Awas.
Now what is happening? Khata was earlier in your name when?
He has been executed in favor to me. And in IML or 18, Khata has been declared in name of the petitioner. Page number 18. Section 8.
You can put it up. Just show me that. Page? Page? 18.
Section
2018. Just where does the name come show? Petition is in 2018. Site number 242. Site number 242. Now what has happened?
Now the e-paper has been cancelled.
As per Neksha, ground that it's not converted land, is it? On what ground it's cancelled?
No, without given proper reasons. Page number 16 for a moment. Last sentence. ಅವರ ಮೇಲ್ಮನವಿಯನ್ನು ಹೇಳಿಕೊಳ್ಳುವಂತೆ ಅನುಸೂಚಿ ಸ್ವತ್ತುಗಳು ಪಂಚಾಯತಿಗಳು ಬಾಯಿ ಮಾತಿನಲ್ಲಿ ರಾಮಕೃಷ್ಣಕ್ಕೆ ಸೇರಿದ ಜಾಗಗಳು ಕೊಟ್ಟಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆ ಬಗ್ಗೆ ಮೇಲ್ಮನವಿ ಎದುರುದಾರರು ಯಾವುದೇ ತಕರಾರು ಸಲ್ಲಿಸುವುದಿಲ್ಲ. ಒಂದು ಮತ್ತು ಎರಡನೇ ಎದುರುದಾರರು ಪಂಚಾಯತಿ ಆಸ್ತಿಯನ್ನು ಸಂರಕ್ಷಿಸುವ ಹುದ್ದೆಯಲ್ಲಿ ಇದ್ದುಕೊಂಡು 4 ರಿಂದ 6ನೇ ಎದುರುದಾರರಿಗೆ ಷರೀಫಾಗಿ ಪಂಚಾಯತಿ ಆಸ್ತಿಯನ್ನು ಹಾಳು ಮಾಡಿದಂತೆ ಮೇಲ್ಮನವಿ ಮೇಲ್ಮನೆದಾರರು 4 ರಿಂದ 6ನೇ ಎದುರುದಾರರಾಗಲಿ ಸುಮಾರು 70 ರಿಂದ 80 ವರ್ಷಗಳು ಸದರಿ ಜಾಗದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಆಧರಿಸುತ್ತಿಲ್ಲ. ಬಗ್ಗೆ ಮಾಹಿತಿ ಪ್ರಕಾರ 20 ರಿಂದ 25 ವರ್ಷಗಳ ಕಾಲ ವಾಸವಾಗಿರುವಂತೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಡಿಮಾಂಡ್ ರಿಜಿಸ್ಟರ್ ಹೆಸರು ನಮೂದು ಮಾಡಿರುವುದು ಕಂದಾಯ ವಸೂಲಾತಿ ಕ್ರಮವೇ ವಿನಃ ಯಾರಿಗೂ ಹಕ್ಕು ಪ್ರಾಪ್ತವಾಗಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ 1 ಮತ್ತು 2ನೇ ಎದುರುದಾರ ಯಾವುದೇ ಮುಂದಾಗಿ ದಾಖಲೆ ಇಲ್ಲದೆ 4 ಮತ್ತು 5ನೇ ಎದುರುದಾರರಿಗೆ ಸ್ವತ್ತಿನ.
But how have you got this? How have you got this originally?
Thereafter, the gift deed has been executed in favor to the petitioner. Page number 23 for me. Election D.
Order for status quo as on date. But you must not create third party rights. Petitioner admits that by virtue of the order The 21 order, why do you, how do you explain the delay? The orders of 21. You take out notice. Let us see, let us see. Chief Executive Officer, Talak Panchayat, Hole Narsipura. Yes. Employee Council, M.S. Devraj accepts notice for response 1 to 3. Emergent notice to respondents 4 to 7. Consideration of interim prayers kept open. This the matter week after next. Yes. Let us see, let us see.
Yeah, man. I'll place it on the record. 8 minutes time.
Let us see the relief you are seeking is to take action, isn't it? You are seeking for taking action. Age? 30.
For the legal action taken in the petition letter to the what kind of response. There should be directly given restore the Papa in the name of the petitioner as to the earlier given by he in the petition. What kind of data from then the directly responsible to return the bidding address by any mother.
No, we'll have it next week. Let us see. Let him take some preliminary instruction, then we'll consider. Then request of council for R1 and R2. List the matter next week. Consideration of interim prayer is kept open. List the matter in the orders next week. You complete the instructions. List the matter on 4th. Orders list. The order? It's already granted. No, then why let it? Interim order is there, then you must wait. No, now interim order is there. You just wait. That will see. Interim order earlier granted is extended till the next day. Let him file his restriction. Interim order is there. Let him.
License is not.
Let us see. Let us.
HD 32.
Want to take some instructions.
It is 1 acre. So this is site is mentioned now.
Let us see. A request made on behalf of respondent number 2. It's the matter week after next. Necessary instructions to be completed by the next day. List the matter in the same stage. Let us see week after next. In the week commencing from 11th of March. Connected marketing. Matter next week. Next.
My lord, in serial number 34, it pertains
Yes.
to Attibele Town Municipality. I appear for the Attibele Town Municipality. Mr. Pradeep's name, I do not know how it is shown.
The town municipal council Attibele. But they have to then carry out the amendment. Have you amended? Have you amended that? But the cost title is not yet amended. Hmm? EMC Attibele.
No, it is TMC, Town Municipal Council.
You appear. Office to show the name of Learned Council Sri S. Mahesh. Mahesh.
Yes, ma'am.
The matter next week.
I have to take notice, my lord. Notice
Yes,
has
yes.
not been ordered, but
Copy.
Mr. Pradeep's name has been shown.
Copy to be served on Learned Council Sri S. Mahesh. Copy to delete the name of Learned Council and Pradeep. Is the matter next week. Let us see. You first serve a copy.
But
Yes. You appear for the BBMP. You have taken steps, is it? Forty-eight orders passed. Passed. Let them take action in accordance with. Order is passed. You filed an appeal. What has happened to that appeal? Will direct. Construction is in which year? Let us see. Correct. But now, since there's a appeal, we'll direct the appeal to be disposed of expeditious. Now we can't pass an order till the appeal is disposed of. No, correct. Appeal is pending. So we can't do anything till the appeal is decided. We'll direct that you can do in appeal, madam. Here now no order can be passed till the appeal is disposed of. I'll pass over. Have a look at it. Now, what we are doing in all matters, if 248.3 order is passed, we close it, recording that after the 248.3 order attains finality, the BBMP to take expeditious action. Pass over. 230. Yes. Yesterday's matter we have tagged along with this, is it? That bridge one. So we'll have it next. We'll have it next week. We have tagged one or two other matters along with this latest. This next week. The matter week after next. Interim ಏನಿದೆಯೋ ಅದನ್ನ extend ಮಾಡಿ. Interim direction not to take precipitated ಅದೇನಿದೆಯೋ is extended till the next day. Yes. 30. In 33. Passover, isn't it? The next relist the matter tomorrow. 3. Yes.
Okay.
No, they are withdrawing the writ petition. Memo file by the petitioner reads as here under. In light of the same petition is dismissed as withdrawn. Compliance of office objection is waived in light of the memo. Yes.
As direct as asked the registrar of society to conduct an inquiry under section 25.
Let us see, you take out from this.
Priorly also, on the same level of application, the inquiry was conducted. And thereafter,
Correct, we'll have it on Monday. Oh, let us see. You serve it on the other side. Who is passed the order? Jilla Panchayat Mandya. Who appears? Jilla Panchayat Mandya. You appear. Council CA, MS Devraj. Just 1 minute. AG accepts notice for the first respondent. First, third respondent. MS Devraj for the fourth respondent. Fourth and fifth respondent. Emergent notice to the sixth and second respondent. Now the order is passed by the Zilla Panchayat. We'll have it tomorrow, get instruction. Now the account is frozen. Friday. Let us see. Monday we'll have.
They are supposed to return need proof to the back. So the back having been chosen by responding to I could not recover the amount. It has been released to the society and in turn has been released to the society. The same allegations were by annexure bench. The society had been absolved. The same allegations were and the respondent number 4 and 5 only had instructed the bank to decrease the accounts after the absolving of the inquiry, in the inquiry. Thereafter, your lordships, on the same allegation, again, by annexure A, your lordships, the order is passed, the letter is passed to the.
We'll have it on Friday, you see if you can do. This is the matter on Friday. At least some preliminary instructions if you can. Friday. Serve copies on the council. So you serve that. What has happened to R3?
The address.
So we have issued a Lucas notice. They are challenging that Lucas notice that Honorable Court dispose the matter after final order response to final order. Yeah, my lord, what happened, my lord? Initially, my lord, they made a part. My lord,
This stay was granted to the 50 kilometers, they were doing the work of the planning authority. They get the stay order, they have issued sanction plan. What is the plans now? Subsequently, the planning authority have cancelled the sanction plan.
No, let that affidavit be filed. Surveyor will have it on Tuesday. Release the matter in the same stage on 5th. On 27th. Affidavit to be filed in the interregnum after serving copy on the other side. Yes.
Serial number 41.
I represent the petitioner, my lord. Last date I paid the demand draft. For 7 lakhs and odd. Earlier I had deposited 4 lakhs and odd. According to me, the entire taxes are paid.
There are no dues.
No dues according to me.
Let him come, let him come. Shall I pass over?
They
Find out
statement.
whatever stand he takes.
Let him
Otherwise,
take
I'll adjourn it. If he were
Adjourn.
to accept it, there ends the matter.
matter.
Pass over.
Instead of pass over any day, other day. Next week, madam.
Release the matter.
On Monday or
Next.
Tuesday.
Yes. On Tuesday.
Interim order may can be extended. Interim order may be extended.
You filed a memo. Last time it was not extended.
It is not. Only last time it was granted, madam. Only last time it was granted.
There appears to be some. Please check the order sheet. There's some mistake, I think. I'm not sure. Please check the order sheet. It says only list in orders list.
Not to precipitate was.
Otherwise, let us see. Let him come. We'll see. And in his presence, we'll pass something.
No objection.
We'll have it at
My colleague will be here. No problem.
Yes. We'll have it at 2:30. Let us pass over. Yes. But correct, according to them, they have to pay only 4,24,541 according to their memo. But your property tax plus cess comes to 11,54,520, out of which 4,50,000 he has paid. Let us see. Now remaining amount, how much, within how much time will pay? As per his, let him pay the remaining. We'll see. And, let us see. Let us see. The counsel for the petitioner submits that in terms of the memo of calculation filed, they are liable to pay an amount of 4,24,541. Let us see. Let us see.
Now, according to the what I have to pay up to 2024, I have paid, so because to finish the deposit, you can calculate.
Correct. Now, what is coming, let it come without prejudice to let him deposit that according to the end of the 41, and the same will be paid by 12th of April. Affidavit to that effect to be filed in 3 days by the petitioner. Full stop. And the counsel for the BBMP has filed a memo. Same is taken on record. Objections to the memo of calculations filed by either side to be filed by the next date. Order should come. This is the matter. The third week of April. The deal is the matter on 18th of April. PDO Kadur Gram Panchayat. The Council MS Devraj accepts notice for the third respondent. You appear, will accept notice. Copies of the petition to be served on the said council. What about R2? R2, you have to take steps. You will accept. You will accept. Council MS Devraj is directed to accept notice for respondent number 2. We'll allow that. No. It's submitted that fourth respondent has died. Petitioner has filed applications seeking to set aside the abatement. Seeking for condonation of delay in filing the application to bring the LRs on record. The application to permit the legal representatives to come on record. In light of the governments of the permits made out in the application, the supporting affidavits. Again, filing the application to bring the LRs on record is condoned, abatement is set aside, and the legal representatives are permitted to come on record and represent the interest of the deceased, respondent number 4. The same amendment to be carried out. Interim order earlier granted is extended till the next day. This is the matter week after next. This is the matter after 2 weeks. Copies, you serve copies. Yes. Because take me through the note. It,
If there is a deviation, next time whether it has to be sent to the authorities, the authority is the right place that has to get included, or it is anything that it's jurisdiction. First of all, I have to establish whether there is statutory deviations.
what is the prayer? Prayer in your written.
Yes, because the Constitution has regarding the facts of the case. Additional are number one. The Ramakrishna Gardens Resident Welfare Association, in the Ramakrishna Garden area, which is a closed residential community, and this is the association. Thereafter, petitioner number 2 to 20 are residents in the association. Now, respondent number 3, what is your property in the vicinity of the site of the community? Started building construction.
The same.
Inside. That is plot number 1 is what is owned by the respondent number 2. The Washington must be this construction is started within
No, these are sites in the same layout formed by the. Yes.
Right.
The construction started and the petition is filed. There was representation given to the committee when there was notice from the petition is filed. Firstly, the construction, one of the challenges is that the construction is contrary to the sanction plan that was granted to respondent. That is one of the players that was. It's a demolition was sought.
Yes.
Secondly, is that the second and most important player is that the sanction plan itself is contrary to the bylaws as well as the regulations. If there is a violation, then it has to be a violation.
Notice of the violations and order for a commission from the BBMP. And a commission was conducted in the presence of both the petitioners and the respondents. And the report was filed before the organization. The report reflected grave violations of the sanction plan itself, wherein one of the violations, if I could point out, is that 11 rules is what the sanction plan sanctions them to build. 33 rules were built. Other than that, there were various other violations which is pointed out in the commission report itself. After the commission report itself, there was an objection raised by the other side stating that there is a notice that had already been issued by the BBMP, that the BBMP take its course. There is an alternative remedy that is available. That was the objection that was filed by the respondent number 3. The court took notice of that and considered in its while granting an interim order, said that alternatively it does not bar a writ jurisdiction when it comes to such grave violations with regard to this regulations. This is what the writ court took into consideration and passed an interim order wherein it states, wherein it appointed a commission for inspection as well as it granted stating that unless the completion of this, the portion shall not be granted, and there was a stay of the construction. This was challenged in a writ stating that the judge's order was wrong with regard to the commission, appointment of commission as well as rejection of the alternate here. This writ court confirmed the order of the civil judge, and a commission was conducted. And after that, after commission was conducted, the commission report was filed wherein grave violation was. Then the respondent number 3 came before this report and stated voluntarily that they will remove certain deviations which have been pointed. There was a court order after that which stated that after they informed the BBMP that they have removed the violations, the BBMP shall once again conduct inspection and file second report. Now this inspection allegedly is being conducted by the BBMP. This exercise has been conducted by the BBMP. Now, this exercise has been conducted behind my back without notice to me. And the report has been at the first instance filed by respondent number 3 and not the BBMP. After which I objected, saying that the report has to come from the authority. They have conducted the inspection. It has to come from the authority and not the respondent number 3. I filed an objection with regard to that, and also on perusal of the report, the parameters that were taken into consideration while the inspection was conducted for the first time, and the parameters that were taken into consideration while inspection report was filed for the second time are very different. That is why in the second report, they say that there is no deviation. Everything is under compliance. That is why I filed my objection with regard to that, stating that the second report cannot be taken into consideration because it was never done in my presence at all. This is how the BBMP has been.
So now you just take me to, so on this aspect, you take me to the second report and your
Yes.
objections filed.
Yes.
Fourteen? Yes. Yes. Document number 2.
there is a master that has been brought. That's my signature. None of the petitioner's signatures are there. There was no notice given to me. And the mother was brought when the inspection has been conducted. It was conducted behind my back. And I have categorically at each time objected that the DVP is not acting how it's supposed to act. I stated that the deviations are not removed in spite of me objecting every time they go and conduct an inspection behind my back. By the way. In fact, the person who is not filed by them is filed by the partner. Now, that is one aspect with regard to my signatures are not there. With regard to your option, Mr. Lordship should take the first report that has been filed.
No, but now to do, okay, let us. Now in your objections, you have brought it out.
Yes, I have.
Now you take me to your objections to this report. Joined a file on 14th February.
Joined the file by me the objection that was given. I have filed a separate objection statement to the report itself. That is dated 31/1/2024. I have filed my objection.
On?
31/1/2020.
Yes. Yes. So what are your objections to that report? Let us have a look at it.
The objections that it has been conducted without my knowledge and the deviations exist even as on this state. There are photographs which I have filed. Page 16.
Page?
16. One photograph which I have filed.
Yes.
This is the recent photograph after the inspection. Your Lordship see how the adjacent is one of the petitions. There is no setback absolutely. It's protruding to the petitioner's house. Whereas, according to the statute, the setback says that for a building which is of 12 meters of height, 5 meters of setback has to be kept. And here there are hardly any inches which is there. This is one of the, in spite of this, that your naked eye shows that there is no setback. In the report, they say that there is absolutely confirmation of setbacks. There are setbacks that have been observed. And also, even in the first report that when it was filed, when my contention is that the sanction plan itself is not in consonance with the zoning regulations as a bylaw. The parameters that they have taken in this to compare the ground reality is that they say that the parameter has to be either the sanction law or the bylaw. That cannot be a parameter because here both are not in sync. The sanction plan is not in sync with the bylaw. When that being the case, they have taken whichever, they have taken or. That cannot be one of the parameters. And they say that only 2.2 and 1 meters enough as a setback. Lordship, in fact, I should bring your Lordship notice in page number 11. I could just take your Lordship to page number 11 of my objection.
Yes.
Lordship, this very photograph is how the setback at the back side of the building is. Even a person, even a worker who did pass through. That is the kind of setback that they had kept. Now, my instructions is that even as on this stage, because if this has to be removed, this whole entire wall has to do it. That has not been removed as my instruction. This was how the state of affairs was initially. Even now, what they say is backside, this is how it is. In spite of that, the DPP goes on to file a report saying that 1 meter has been kept. And even my contention is that even 1 meter is too less because the statute demands you to have 5 meters as the setback.
Now you come to the zoning regulation.
One of the clear is that the sanction plan itself is wrong, and that has to go. Why? Because it is not in consonance with the rural regulations, neither is it with consonance with the building bylaws. One of the foremost contentions that admittedly this is the residential mixed area. And the contention that was stated by the other side, also contention stated by me, that there is this particular sanction plan is recorded for a hostel that has to come up.
The plan is
closed.
plan is for
The plan is for a hostel. Plan is an annexure C, page number 49 of the petition. The purpose of the plan is for plot use is residential. And then some use is hostel. Like a 33 room was built. The right side.
Plot is
Plot
residential.
The next line is that some use is hostel.
Yes.
Contention of the respondents is that since it's a residential mixed area, hostel is very well enough to be come up with that residential mixed area because this is what the zoning regulations, one of the permitted uses what the contention of the other.
Yes.
Even if you take into that consideration, there is a notification by the BBMP itself at annexure B.
Then yes.
This is the notification with regard to the zone, how zone, what are the permitted activities in the zones is what this notification is about.
What is the date of the issuance of sanction plan?
Action plans are included.
10/6 2020 2020
6/10/2020.
6/10
BBMP Act came in 2021.
now what is this notification?
This notification is with regard to zoning regulations. What are the permitted in a particular zone? Now, this particular area comes under residential use. Technically, it comes under residential use.
Yes.
Now, this the permissible uses are categorized. Whether it says that in a residential unit area, hostel can come.
No, but take me to that mixed, what is it is? Residential?
This notification, the first,
Yes.
there is a column down. Permissible uses in the residential category.
Yes.
Where it says, in point number 3, it says hostel are allowed in residential category.
So this permissible use in residential category applies also to mixed.
Yes,
Yes.
but my worry is that the first part of the note.
Yes.
First part of the notification, rule number 1 says that no commercial activity of whatsoever nature shall be allowed in a residential main and residential mixed zone in the 3 rings in 1, 2, 3 if the road width is less than 40 feet.
You are saying that
The road here, in the sanction plan, it says the road is 9.14 meters. In the report, it says just 9 meters.
you say,
According to this, it says that unless you have 12.5 meters of width, they could not have sanctioned for a hostel facility to come in the residential area.
so according to you, under note 1, this hostel will be a commercial activity because the road width is
Yes,
less.
it's not associated with the college. It's being conducted for a commercial activity where they're letting out.
You are saying that so the table which provides for permissible usage will not apply.
Yes. They ought not to have given a sanction itself. In fact, I can produce other sanctions which is let out for a hostel facility in the same vicinity, wherein the road is beyond, is above 12.5 meters. In that case, they can sanction for a hostel facility to come in a residential area. Your Lordship, the intention is very simple. It's a residential area. The road width is 9 meters even according to the video. In the 9 width road, if you allow a hostel facility to come up, the kind of promotion and the kind of stress that the area would undergo with regard to the congestion is more behind such regulation. That is why, unless the road is beyond 12.5 meters, they cannot be a hostel facility that can come up. That is my foremost contention.
12.5 meters.
Yes. 40 feet also. So, one of that, my contention is that the sanction plan itself could not have been given for a hostel facility when the road itself is a narrow. Second contention is that the building bylaw of 2003 states that what is the setback that has to be observed when a particular height, when the height of the building is a particular height. Now, the height of the building here sanctioned is 11.40 meters. But according to the other commission, the building has been built up to 12 meters.
Just go to that. Let's see what they have mentioned in the report. Second report.
The last one. As per sanction plans, 11.40, but we have allowed them to construct, so they have constructed 12 meters. The second.
Says point 0.6. Yes.
Even if 11.40 now, they have constructed beyond the possibility. Even if it is to be taken as per the sanction plan, why the sanction plan itself is wrong? The setbacks when it comes to the height is wrong. Is because according to the bylaw 9.2, it says that the setback for a building above 9.5 up to 12 meters is 4.5. That has to be observed on all sides.
Take me to the bylaw. Bylaw number?
9.85.
Bylaw number?
9.85.
Yes. Table 4.
Because the height of the everything is above. Then above 9.5 up to 12 meters. 4.5 setback that has been observed on all sides.
Now, what is the,
In the sanction plan, they say you observe 2.2 in the front, 2.2 in the back, and 1 meter.
here, what is the height?
The height sanctioned is 11.4. It is 12 meters.
It is 12.
Take according to what is being the structure there, we have to observe not even 4.5, they have to observe 5 meters.
Now, the setback in the sanction plan is below 5, 4.5.
It is 2.2 and 1.
Take me to the plan.
Page 49. Section C.
Where do you get the setback?
First, front and back is 2.2. The side is 1.
The table on the right hand side.
Left hand. First table.
2.2 and
And then the side is 1. Those are the set. And that is reflected even in the chart.
yes.
One more aspect is that
You have to give an enlarged copy. Only you can see. Yes. That's okay. Now for the time being it's so. Yes.
one more aspect is that height is going to swap me to the master plan is that the floor area ratio is 1.75, which is enough by both the master plan as well as the bylaws. The plot area here is 222.83 square meters. So basically, when a FAR, that's floor area ratio is computed, there are certain exceptions which has to be left out, and there are certain inclusions which has to be done. This particular exceptions you will also find in the sanction plan itself. What are they excluded while computing the floor FAR? Here. And when computing the FAR, they do some reduction. Now, according to the sanction plan, what has been deducted is staircase, lift machine, void, and parking.
Yes.
According to the master plan, this staircase open balcony staircase is corridor which has been excluded or to have been included. Now, what happens if it is included? Their floor area ratio exceeds what is permissible.
Where do you get that in the master plan?
Be by around 9 point. Even in the
Last two.
even in the repetition, it has been next.
Yes.
Which section? Point 4 of the master plan. Point. Clause 2. According to this, is.
3.2.1, the ratio of the floor area to the plot area is FAR. However, it includes estimated open balcony, staircase and corridors. That is to say,
So there's a violation in calculation of FAR.
yes, FAR.
And so far as this is included.
Yes, still, compare it with your sanction plan. We have done those as deductions. We have not calculated those at the staircase and by calculating the FAR. What happens is that why you do that? Your FAR increase, if you deduct that your FAR increases with the permissibility. That is what will be.
So the FAR given is more because they have not excluded. Yes.
This is regard to how the sanction plan itself is a violation. Roshan, ask me a question, why it should not be sent to the authority? Why is it then enable to the jurisdiction? Firstly, your option, the contention by the BBMP was that the BBMP very well has a provision with regard to which takes care of all these aspects, and the BBMP is the right authority which I ought to have done. Firstly, my foremost contention is that the BBMP Act in this particular case does not apply because the sanction plan was recorded according to 2020 itself, and the BBMP Act itself was not in existence. The sanction plan is dated 6/10/2020, and the BBMP Act came into place on 11/1/2021. My plan was according to the Karnataka
Municipal Corporations Act.
Municipal Corporation Act. Now, in municipal corporation also, it was what your options notice that there is a provision which takes care of all this. When I have a provision, I need to go to PAT or to go to the district. Now that particular provision is with regard to 376. Four
14.
443A.
Corporations Act.
Municipal corporation.
443.
Any person agreed by the notice, action taken was supposed to be taken by the commissioner. Under section 308, 309 and 321 may appeal to the Karnataka appellate tribunal. In case of the BBMP, to the district court having jurisdiction in case of other population.
Yes.
With regard to the action taken by the council or the actions to be taken with regard to these three sections, is where I can go to the PAD or I can go to the. Now, what is 308, 309, 321? With regard to when a building has been built in violation, is when those sections enter. There is no provision to say that when the sanction plan itself is in contrary to the regulations or the building bylaw. That does not cover under this. Section 308.
The 443(1). 443(1). Every license or permission granted. Which is appeal provision 443.
A.
Yes.
Is with regard to any of the notices or action taken or to be taken with regard to these three sections, that 308, 309, and 321. Now, what is 308? 308 is the power of the commission to require alteration of work. Now, there is a building that has been built in violation of, or it is in deviation of the laws. Then the appeal shall go to the PAC under the old act. Or
What is
309.
what is 309?
309 is topic for endangering human life. And 321.
We are saying sanction plan cannot be challenged under 443.
Yes.
Yes.
And 321 is with regard to demolition. My contention was the sanction plan itself is in violation.
Yes.
That is why my contention is that the writ court is the right court. In fact, time and again, this honorable court as well as the Supreme Court in the very same subject has held that the writ is the right court and a technical objection with regard to an alternate remedy that is available cannot be taken into. If I can take the citations.
No, let us see let's see what they reply and then we'll come. Prima facie, they are saying that there is no provision. Be tomorrow or at 2:30. Tomorrow. Now you know what she has argued. You come back to me. This is the matter at 2:30 for further hearing. Note 5 by the petitioner. The synopsis filed by counsel for R1 and R2 is taken on record.
Now they have start for all the Telecast. Even for the sake of they have to update it for the quota. Here they are also that they have given an amount for the executive development. They are raising so many questions now here. And basically, they already want to have earlier reputation. That's what you are taking to the page of 44 of the
So in case there is a dispute,
85,000. 1 lakh, 1,000, 10,000. Now they have raised so many questions. And also, the PDO is accepted to pay the amount, but he is not accepted to pay, return the amount for the export, input of the petition.
No, now in case this is
Now, okay, I get it. After the direction of Mr. Rupert, I will appear before the court. Direction for the last
on 12th of
okay. And the release of the 21 was 2 time. 42. Or appear I last time appear I.
no, just read that order.
Order.
Now he has presented himself before R5. No, that you find that no that you find out what has happened. I don't know. No, you no correct. You file a memo on what has happened on the day when he was asked to appear. Okay, later. Okay, we'll hear it. This is the matter in B group. Week after next. Yes, next. You filed. Statement of objection is stated to have been filed by counsel for R2. Matter week after next in B group. Next. Has to be heard. Then let's hear it. Let's see what it is. What is it? If it requires hearing, let it come for a detailed hearing. We'll have it.
As per the last, board address and submission round, just now received, popular.
One counsel for the responding number 2. To find the copy of the ground report. Same is taken on record. This is the matter in B group.
But pertaining to Netaji Subhash Chandra Bose Airport, one has been completed in all respects on 31/1/2021 itself.
Let us this is the matter in B group week after next. Let us yes. Second respondent. Next week. What is the matter?
Side of the land.
Now you say that road is abandoned. Tomorrow, let us see. We'll have it tomorrow if he comes with tomorrow. It has been abandoned, so it has to be changed. Let us see. Yes, next. Let us see. At request of R4, list the matter week after next. It is submitted that objections to IA 1 of 24 will be filed by the next date. Next.
Number 50.
EDLR report. So you file it. So AGA submits that the survey report by the jurisdiction ADLR will be filed within 3 days after serving advance copy on the other side. This is the matter week after next. Yes, sir. I said affidavit. Put. That's okay. No, he has been, sir, read by name, is it? Let us see, you array him by name. The memo. Yes, memo file. With council for R3 and R4. Furnishing details of the executive officer at the relevant point of time. Said the officer is permitted to be arrayed as an additional respondent in light of the nature of a dispute. Full stop. Emergent notice to the said executive officer Narsimhaya address to the address shown in the memo. This is the matter week after next date. 6. Yes. Petitioner is permitted to carry out the amendment. As the said impleading applicant is not yet served. Notice is ordered, though the said officer is impleaded.
52.
Yes. Mentioning at 2:30. It will be uploaded now. It will be uploaded. All mentioning at 2:30.
Court officer. Court officer.
विन द विकेट इन दोनों ही बल्लेबाजों के बीच और भागकर आराम से ये 2 रन जो है वो इन दोनों बल्लेबाजों ने पूरा कर लिया है। अगली गेंद लेके चले।
Court officer. Court officer. Court officer. ಏನಿಲ್ಲ, ನೀವು ಸೀರಿಯಲ್ ನಂಬರ್ ಕೂಗುವಾಗ ಸ್ವಲ್ಪ ಮೈಕಲ್ಲಿ ಹೇಳಕ್ ಹೇಳಿ, ನಮಗೆ ಕೇಳಿಸೋದೇ ಇಲ್ಲ ಯಾವ ನಂಬರ್ ನಡೀತಿದೆ ಅಂತ.
ಹೌದಾ?
ಸಾಹೇಬ್
ಆಯ್ತು
ನಮಸ್ಕಾರ.
ಆಯ್ತು ಸರ್, ಹೇಳ್ತೀನಿ ಸರ್, ಹೋಗ್ತೀನಿ. ಆಯ್ತು.
ಅದು ಇದು ಅಪ್ಲೋಡ್ ಆಗ್ತಾ ಇರಲ್ಲ ಬೇಗ ಬೇಗ,
ಹಾ ಹಾ
ಅದರಿಂದ
ಆಯ್ತು
ಆಗ್ತಾ
ಸರ್,
ಇದೆ.
ಆಯ್ತು
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು, ನಮಸ್ಕಾರ. ಆಯ್ತು ಊಟ?
ಆಯ್ತು ಸರ್, ಆಯ್ತು.
Triple 14122. A request for dealing in this matter. They had approached the CH-8. CH-8 had dismissed for default. Against that, this order is bill is filed.
There's nothing to do with.
So far as the other matters are concerned, that question is not involved. Here it is only CH-8 has dismissed for default. Challenging that, they have come here. 1141
Billing card. Billing. 3.2 billing card. 3.1 billing.
3.2 has been delinked. You are saying 3.1 has to be delinked. 3.1 also has to be delinked. You file a memo at Learned Counsel for the submission is made on behalf of the petitioner. Respondent number 3 and 4. But what about the petitioner? No, correct. Now, whether petitioner wants it to be clubbed along with this or dealing, we don't know. File a memo, then I'll relist it. No, correct. So we'll relist this on the memo tomorrow or day after tomorrow. Memo filed by counsel for R3 and 4 is taken on record. List the matters on memos for orders on Nale atho Nalidan. So that then tomorrow he'll come and they will attack me. Huh? It's not coming. Tomorrow. See number? But in the orders list on 29th. But earlier grant is extended till the next day. So next. This is the matter next week. The Council Shri P. Vivekananda is directed to accept notice for respondent and the AG is directed to accept notice of the first respondent. Yes. Yes. No, where is it in your name? Where is that? Age 50. That Nagesh and Meenakshi. This is in the year 2000. After the gift deed. 2017. What is this cancellation, government? What is this cancellation of this? All khata saying Iswattu. In many matters, now they're cancelling the khatas on the earlier ground that it's not converted. Some government circular is there. Let us see. Let us see. In light of the submission that e-khata has been effected in the name of the petitioners on 15/7/2017, and that same is sought to be cancelled. The ground that it was made wrongly. Land in which the sites are found are revenue lands, subject to further consideration, there will be stay of the proceedings at Annexure A and consequent actions pursuant thereto. He is directed to accept notice to the first respondent, Malur. Council Sri D. Narayan Swami is directed to accept notice for respondent 2 and 3. Emergent notice to respondent number 4. Interim order will be enforced till the next day. Very prospective. Let us. Yes. 35. Order?
lost, this is demolished or violation of the plural. If you, and the objection of whatever we can.
No, no.
Already. So whatever the
You have not raised any objection on the second floor. On the second floor. Where are you reading? Page 20. Yes. Yes.
And the owner of the property has been presenting third floor of the direct below the own for the proper position of behavior. And nowhere on the second floor, second floor stands in the section. And they are appealing in regards to the second floor.
Yes, sir. Now the 248 proceedings is regard to second floor. Counsel for the respondent BBMP. Find the memo and place on record. Notice under 313, comma, order under 248(1), comma, notice under 248(2), and copy of the order under 248(3). Perusal of the same would reveal that the same is limited to the unauthorized construction on the second floor. However, petitioner, full stop. Next, petitioner submits that the present petitioner seeking for action in terms of the representation at Annexure A as regards construction of third floor, which is not only not the subject matter of order under 248(3), but is also construction beyond the sanction plan. Isn't it? Accordingly, responding BBMP to take its stand insofar as the construction complained of at Annexure in the representation at Annexure A by the next day. Now you see A and C. Now she's saying that third floor is not part. Now if we had simply said closed, then she would have been aggrieved. Find out. List the matter next week in the orders list. You want to include that portion, you include it and take proceedings for that. Yes.
Serial number 41.
I represent the petitioner, below.
Yes, please.
Pawan Kumar. No, they say they have paid
4 lakhs and 7 lakhs and all.
41.
41.
They said They have paid the entirety of dues. There is nothing more remaining. That is their stand. Just use the mic. Use the mic. So
I have paid the entire amount. On the last occasion before court, I had tendered a demand draft for 7 lakhs and odd.
just 1 minute. Just 1 minute. Matter. The same stage on next week date. Now they're saying that in the interregnum, don't take any precipitative action.
That's all.
The interregnum, subject to further consideration, the respondent BBMP not to take any precipitative action in light of the submission that in terms of the petitioner's instructions, entirety of the demand has been satisfied.
With your lordship's kindly, serial number 86, my lord. I'll pay the
Yes.
amount day after tomorrow. Serial number 86.
86, sir.
86, I'll pay the amount day after tomorrow, my lord.
You want it next week?
All right.
86, sir. Release the matter on same day.
27th of
29.
April.
29.
March. Huh? Password. Huh? Any urgency? Have it on Monday. The matter. Some new amendment has come. Have it on Monday. Release the matter in the same stage on 56. If you pay 40% of guideline value, you can construct till the sky. Huh? The same stage. So many builders like Sudhakar's clients will now go to the sky. Yes. Just one, I'll come back. So how much time you require?
One is concerned. Petition is filed by a housing cooperative society. It has six sites registered in its name, residential sites. And there are moreover 132 residential sites, which are already registered in favor of the members of the society. Now, from the year 2018, on the basis of the order of stay which is granted in so far as to maintain the status quo so far as city community site is concerned. Tata is what it is. So far as the owners of the property, 2018, You know, the kindly see the representation which I have addressed at annexure A. Has no bearing on suitability. Annexure A is the 60.
But the endorsement given, of course, may not be correct. But for a petition, he is not. Yes, don't get proper. That point they have Rule 20. Rule 20 of no, good. This will come to you. Now, what is the relief you have sought for?
Page 90, page 21. These are the representations we have got in so far as
Read one of them.
ये kind of mistake is like page 16. ये kind of mistake is ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೇರಳದ ನಿವೇಶನದ ಖಾತೆಯನ್ನು ನಮ್ಮ ಬೇರೆ ಹೆಸರಿಗೆ ಮರುಪಾವತಿಸಿ ಬೆಂಗಳೂರು ತಾಲೂಕು ದೈತ್ರಾವತಿ ಕಡೂರು ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸಂಘ ನಂಬರ್ 43/2 ಇಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಜಮೀನು ಕೃಷಿಯೇತರ ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಅನ್ಯಾಕೃತ ಜಮೀನುಗಳಲ್ಲಿ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನಾ ಇಲಾಖೆಯಿಂದ ಅನುಮೋದಿಸಲ್ಪಟ್ಟು ನಿರ್ಮಿಸಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿರುವ ದೂರ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಆಡಳಿತ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟ ಪೃಥ್ವಿ ವಿಸರ್ಗ ಬಡಾವಣೆ ನಿವೇಶನಕ್ಕೆ 2 ದೂರ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ನಮೂನೆ.
Now you have formed a layout.
Layout is formed by with them I enter into an agreement and subsequently I purchase some land. 6 sites are in my name.
Society is
housing cooperative. And because on the basis of the agreement for sale, I have sold all the property of all the sites as a confirming party to the members of the society. Now the sales are transferred from 2012 to 2018. All the properties are sold as on. So 2018, what happens is there is a lease from sale date which is executed. But what happens is Panchayat executes the sale date in favor of a trust called Nagamma Charitable. So that is challenged before the Panchayat. And an order is passed cancelling the sale date which is executed in favor of the Nagamma Charitable. That is challenged before the Honorable Court in 53.1. In the 53.1, what happens is status quo which is granted. On the basis of status quo order which is passed by this Honorable Court, by representation to issue kata is not considerable. Now may kindly see the endorsement which is given with us, which is that is 26. You think around. ಏಕೆಂದರೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೈಸೂರು ತಾಲೂಕು ಜಯಪ್ರಭು ದೂರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ನಾಗಮ್ಮ ವೆಂಕಟರಮಣ ಬಡಾವಣೆ ನಿವೇಶನಕ್ಕೆ 4ರ ಖಾತೆ ಕೊಡುತ್ತೀರಿ. ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ದೂರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಡೂರು ಗ್ರಾಮವು ಸರ್ವೆ ನಂಬರ್ 37/43 ಮತ್ತು 10 ಎಕರೆ ಜಮೀನು ಬಡಾವಣೆ ಮಾಲೀಕರು ನಾಗಪ್ಪ ಬಡಾವಣೆಯ ಸಿಎ ನಿವೇಶನದ ವಿಚಾರದಲ್ಲಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ಚಾಲಿಸಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಕಾರ್ಯನಿರ್ವಾಹಕರ ಅಭಿಪ್ರಾಯಗಳು ತಾಲೂಕು ಪಂಚಾಯತ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಡಾವಣೆಯನ್ನು ಸಿಎ ನಿವೇಶನದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಪಡೆಯಲು. In order to
3.1 relates to execution of CA site by the society to some person.
What happens? The sale deed is executed by the Panchayat in favor of an Nagamma charitable. Thus, which is the petition in 53.1. It is in so far as civic community side is concerned.
That has nothing to do with the remaining.
Yeah, it has nothing to do with the remaining. These are the residential sites. Moreover, sale deeds are executed by the housing cooperative, the petitioner, as a confirming party with the original land. No, in order to arm twist the petitioner in 53.1, they are not issuing the kata. And the owners are not able to sell the property. Property tax is also not being. In 2018 to 2024, the statement of objection is also not filed by the government. In 53.1.
You want the kata first in your name, and then it will go into the name of the new No, your request is first that it has to come to the society's name. And then whatever said that will have to be separately considered.
Representation. Because page number 16 to page number
20.
21. His representation got into my right. His representation there, I am the owner of the see, 2022. Sorry, page number 22. I have addressed the representation on 22 to 25. I have addressed the representation on behalf of the members of the society. See, the issue kata is their name. So perhaps the incidental states that are formed.
Correct. Now, so far as the page 17 to 20, you have sought in your name, isn't it? For certain sites. Now, those sites, it has to be in your name. And for remaining other sites, you have made a representation at A1 onwards. For the other members of the society. Now, that has to be considered. And that has nothing to do with the next. No, that's all.
He's not the owner, but according to never. He has sold those properties to members. That's just those members has to apply. Their name can be.
Without first kata being in their name.
No, it's not right. I don't like it.
No, where the kata is not affected in the name of the society. The 6 sites are what? Correct. Those 6 sites are retained by you. You have not sold it. So, annexure A to page 16 to 20, it has to be considered. 21 has to be considered. Remaining one, you are saying it's made on behalf of the site holders. However, the supplementary application will be made on behalf of by the site holders directly to them. Now, these has to be disposed of without reference to the pending litigation. That's all.
But he's the owner. If he's the owner, it will be he's not the owner, it cannot.
So these will dispose of without linking it with the other one. Whatever procedure.
Thereafter, if he is the one, if he accepts that owner, he put it on
The present petition is dealing to serial number 53.1 being disposed of separately. Petitioners sought for issuance of writ in the nature of Satyavada to set aside the endorsement at annexure B by the respondent number both responded. Whereby it is stated that light of dispute relating to CA sites, the application of the petitioner cannot be considered. The petitioner has also sought for issuance of writ in the nature of mandamus to direct both respondent to consider the representations made on 3rd of August 23, 17th of August 23, and 18th of August 23, and to Khata certificate with respect to the residential sites formed in the property belonging to the cooperative society. Correct. Now, because of the endorsement, I'll clarify that. It is a case of the petitioner, Prithvi Housing Cooperative Society. What is the name? That they are the owners of 6 sites. That is site number 2, 3, 4, 18, 19, and 20. And have retained ownership with respect to the said sites as on date. It is submitted that approved layout has been formed, in which these sites which have been formed, and ownership is retained by the petitioner society. It's further submitted that Gram Panchayat Form 9 and 11A have been issued previously for the respective sites, but despite request being made, now what is it? But despite request being made, Khata is not registered in the petitioner's name. Insofar as sites at number so and so, counsel for the respondent, both respondent submits that the same would be considered subject to furnishing of all necessary documents by following the procedure, including notice inviting objections, without reference to the dispute relating to the civic amenity site. In light of such stand, as it is contended by counsel for the petitioner that the dispute relating to civic amenity site has nothing to do with the request of Khata made by the petitioner as referred to above. The endorsement at annexure B is set aside. The request for Khata already made, or if required, to be made in prescribed format by the fourth respondent, to be considered in accordance with law, independent of the dispute relating to CA sites, referred to in the endorsement at annexure B. Next. Insofar as the request made by the petitioner society at annexure, now this is only for those 6 sites. That's all. A1 and A2. That we'll direct the, insofar as the representation at annexure A1 and A2, it is submitted that the requests which are identical to the requests made at annexure A relate to sites that have been sold to the members. If that were to be so, as rightly pointed out by Learned Counsel Shri B.J. Somayaji for R4, in terms of Rule 20, of the what is this?
Karnataka.
In terms of the Karnataka Gram Swaraj and Panchayat Raj within brackets. Village Panchayat taxes, rates and fees, close inverted comma, rules 2021. The station of Kata can be only by the owner, and accordingly, insofar as the subject matter of annexure A1 and A2, no direction can be passed while reserving liberty to the owners to make appropriate application in prescribed form, which to be taken note of by the authority appropriately. Accordingly, petition is disposed of. Now the endorsements at annexure, which are set aside now. Annexure, accordingly, endorsements at annexure B to B5, that is relating only to A. B to B5 are set aside. Now in 53.1, list after 2 weeks at request made on behalf of the state. Yes.
The problem I thought was that the endorsement has been issued. Was going to obviously sanction and then it was sought by the fifth respondent to my petition has been taken by the petition. Then like mother connected to the facts. Then mother challenge the endorsement by virtue of which respondent will find
Connected multiple, connected multiple. WP 4703 of 24. Okay, so let them now. You will accept notice. Council here. Pawan Kumar accepts notice for the respondents. What is to be done in that? No? What is that order? Need not be.
And on which the construction starts, the neighbor complains. What is the locus standi of the neighbor? Because this is not a property. And the 7.2, according to me, that it doesn't require the right.
Small size. What is the position now? G8. Which are those petitions?
Less than 60. This is a plot with a width of less than 6 meters. That is some person who is before the court in the other petition. No, these rights are affected, the remedy is by way of suit.
Immediate neighbor, I have produced the photograph. Not even a single inch of setback murder to sort with that. And it is like this, then the murder I have also produced. Ultimately, my right murder.
Now, no decision is yet taken, is it? Less than 500. Now, shall we club it with that or we call it? Huh? Like. Same matters. There is a direction with respect to those below 500 to the government to frame some rule. To frame some rules. Shall we have it along with that? I'll just say next week. And then you just find out what's happening in those. Let the government know. Because if it's less than, but I thought that less than some thing, there's no setback under the building bylaws. Huh? Under the building bylaws?
That also table 4 will be
7 point? You go to table 4.
Here, open spaces covering to area reach a number of roads and highways. If it is a residential, front one, I'm at table 4. Table 4. Front is 1 meter. Rack, there is no setback prescribed. But similarly for commercial, it is front 1 meter, rack no prescribed section.
Only front and right. Front and right.
Front and right for residential.
What do you say?
Setback.
No, that he will that he may comply. That he will comply.
Also be required that the given building side of required to be followed in terms of the terms of the daily life. 3.1
No, yes. No, correct. Just only now, in terms of table 4, there is some setback. It says in the front and the right of 1 meter. So that they will comply. So that will see.
As far as Setback is one of the aspects, but what has come to the light now is, there is no sanction plan.
No,
There is not a construction that has been.
No, just one. Now, what is the construction put up or starting? No, then we can do one thing. Whatever construction, now they cannot go ahead without. Now, why don't you apply? You'll observe this in terms of this, and in terms of that, you give it.
Has been upgraded and rejected. Now, that
Reject-
is what is called
Rejected on what ground?
Rejected on this ground. But the Karnataka they have the section form. And they should have been release of the certain sites in manner in favor of the authorities had not been made. And that is the reason manner that has been cited.
No, how can that come in the way of next year page 29?
Page
That is
20.
the very same endorsement, page 29. In 4733.
Just read it, please.
ನೇತೃತ್ವ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ನೇತೃತ್ವ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀಮತಿ ಸ್ವತ್ತಿಗೆ ನಕ್ಷೆ ಮಂಜೂರಾತಿಗಾಗಿ ಯುಒಡಿಬಿ ಅಂತರ್ಜಾಲ ಮುಖೇನ ಈ ಕಚೇರಿಗೆ ಉಲ್ಲೇಖ ಅದರಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ತಮ್ಮ ಮನವಿಯ ಮೇರೆಗೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲಾಗಿ ಉಲ್ಲೇಖ 2ರಂತೆ ಮಾನ್ಯ ಪಿಟಿಎಲ್ ಅವರ ಕಾರ್ಯಪಾಲಕ ಅಧ್ಯಯನದವರು ಪಶ್ಚಿಮ ವಿಭಾಗದವರು ರಾಜರಾಜೇಶ್ವರಿ ಬಡಾವಣೆಯವರು ಪ್ರಾಧಿಕಾರದಿಂದ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಜಮೀನುಗಳಲ್ಲಿ ಹಾಗೂ ಹಂಚಿಕೆಯಾದ ಸಭೆಗಳಲ್ಲಿ ಹೊಸದಾಗಿ ಖಾತೆಯಲ್ಲಿ ಕಟ್ಟಡ ನಕ್ಷೆಗಳ ಮಂಜೂರಾತಿಯನ್ನು ನೀಡದಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರಿದಂತೆ ಉಲ್ಲೇಖ 3 ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನಾ ಕಾಯ್ದೆ 1961ರ 17 ಅನ್ವಯ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಬಿಡುಗಡೆಗೊಳ್ಳದಿರುವ ನಿವೇಶನಗಳಿಗೆ ಖಾತಾ ನೀಡಲು ಅವಕಾಶವಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಬರುವುದು.
And these how you can ask the site holders. You must ask directly the authorities if they are found. That Council Pawan Kumar submit. This first time it's coming, isn't it? Yeah.
Second time.
You have accepted notice. Okay.
It was listed on 15/2/2024. Directed to be called today.
Learned Council Pawan Kumar accepts notice for response 1 to 3. It is submitted that insofar as Annexure G, necessary stand will be taken as a counsel for the petitioner contents the requirements or matters to be addressed by the authorities and not at his end. Deal is the matter next week. Petitioner is permitted to amend the prayer column insofar as the impugned annexure is I try column A. Necessary amendment is permitted to be carried out. Interim order. Point 1 is extended till the next day. In 54 is extended till the next day.
If I Indian direction law. This one is for 15/11/2024. Can you see now? Either we have to other thing taken 3 days ago. These accommodation 15/11 not the direction of issue. They pursue your law. Actually, want to pursue your law.
No, now, correct. Now anyhow, there is a stay of construction.
Yes, sir. He has already constructed. Because he is not receiving. But others also. Even angliಗಳು ಕಟ್ಟಿ ಬಾಡಿಗೆ ಕೊಟ್ಟು now not by status quo his rights are not impacted. He is happy. Continue the and this BBMP law has not passed the inspection right from now on. Next is law that there is nobody. Adverse influence may be gone. The other side also has nothing to say. It's not there. Let there be a direction law. Allah, if that my prayer is only to consider the representation and take immediate action. You can take, because they are not.
Let me dispose it up.
How the action toward it made. Because we have the right, right in the face of, he has no,
The,
he may be recorded to know that the legal construction has to do something. They must get another way about it.
petitioner is out for consideration of this issuance of writ in the nature of mandamus to consider the representations at annexure A2, A3 by petitioner submits that the private respondents and have been carrying out commercial activities. And have set up commercial establishments in the property, which construction was without plan or license. Further submitted that the khata has not been registered, nor land revenue has been, nor the properties have been assessed to land revenue. Light of the same, the petitioner has asked for action against the said construction. Apart from seeking for a halt of construction as well as issuance of khata. It is submitted that though there have been the private respondents have completed their construction, to date no action has been taken to address the grievance as made out in the representations at annexure A2, A3. Petitioner also sought for issuance of writ in the nature of mandamus to issue appropriate directions to respondent 1 and 2 to take action against the third respondent's continued commercial use of the premises in a residentially converted land. That counsel for the respondent BBMP, representing respondent 1 and 2, submits that the representations at annexure A2, A3 be considered necessary orders passed in a period of 6 weeks from today. 6 weeks from today. 6 weeks from today. Accordingly, petition is disposed of.
And there are lordships may see directions were issued. They may be reiterated, otherwise they will pass a generic order. These issues may be covered. May I persuade you not? If you take then any construction carried out in land sanction India, building license India, these issues may.
In terms of the interim order passed on 15/11/2023, this court, paragraph 3 had passed detailed direction, and the same must also be kept in mind while disposing of the representations as directed above. Huh? But now have they completed or they're doing it?
appreciate a lot, but the direction was not to water spacing. That the direction in the event so and so carrying out so and so without obtaining shall ensure that there is no further construction. In direction to the
Because if they don't take, then they'll be exposing themselves to contempt. No, correct, but now if they've completed construction, what order? Say till you consider you at your end you no, that we can't order, but we'll ask the BBMP to take it. The respondent BBMP, in the meanwhile, before final disposal of the representative, prima facie material being available, okay, direct the fourth respondent if records are so, if records would support such an action to restrain the fourth respondent from carrying out any further construction. And such direction may be implemented, if passed, may be implemented with the assistance of the local jurisdictional police. Yes. Correct. In the morning, you were not there. One or two matters we passed over. You should be there when the matter is called out. Not this matter. Other matters you were not there today morning. 2-3 matters were passed over. Now, when will you file? When will you file? I'm going to fix a date. When you are going to file? 2 weeks. Realist the matter. Correct. No, you must file, isn't it? Realist the matter on 6th of March. And a statement of objections must be filed by such date. Let us see. Stay of what? What is endorsement? Let us see. Let them put it in writing. Let us. A week's time granted. Week's time granted. Through the needful, he submitted that the process fee has been paid. Office to verify as to whether notice is issued to. Yes. It's a matter.
Instruction confirmation order is passed. 48 things passed.
So then you place it, we'll record it and close it. Unless, no, if they pass two for. If you can place it, then we'll have it tomorrow, day after tomorrow. Relist the matter on 23rd in the same stage. Yes. You serve a copy on them also. Serve a copy on both sides. Now you have a look at it. What is the report that is filed? And then you take your stand. This is the matter next week. Report, inspection report is filed along with memo. Same is taken on record. Notice to be served on the petitioner and the other private respondent. This is the matter next week. We'll see next week what is to be done. Yes. You have to file. You want inspection is done. You want another date to be fixed. Inspection is not done. So we'll fix another date for inspection. That a request made on behalf of the respondent. The inspection date for inspection is refixed as 4th of March or early date you want. 4th of March at 11:30 a.m. You serve it on them and then file it. The matter. I think not to take any precipitation. We'll list the matter next. No, correct. What we were thinking after the report comes, then because till the report is done, next there will be contention that no notice is served. So after this stage, then we can do some more. It's submitted, that report would be filed by the next week. It's the matter week after next. Interim order earlier granted is extended till the next week.
62. 62.
But there's still some difference. You serve him a copy. So I'll take this on record. The memo file. The counsel for the respondent has filed compliance report. Same is taken on record. This is the matter next week. For the interim order next day. Yes.
From the executive engineer also. And this was on Friday, we are going to visit the property. They are ensuring that they reach the provision and because of
Of course, we need to only completing matter, we are doing what was going in front of matter. Because implementation is zero by this and direction by the South of Florida, not the slip from 2 to 1. And now they are looking conceptually going on. They are just
That counsel for the respondent submits that inspection will be completed during this week. Relist the matter on Tuesday. By then you have to take. Let us see on 20. Now the sanction plan. Now there is plan or no plan? Let us see, Tuesday. Yes. 28. Let them file the report. At request, is the matter week after next. Report to be filed by the next date after service on the other side. Interim order earlier granted is extended till the next date. That you give it in writing, whatever. Office objections to be complied with. Same order. Same order. Yes, yes. In light of a request made on behalf of the respondent, the date of inspection is refixed as 4th of March 2024 at 11:30 a.m. Interim order granted is extended till the next date. So carried out the inspection or what? First list the matter week after next. Report as directed to be filed by the next date. Let him place it. Let him place. The matter on 28th, by then you file it. Report as directed to be filed. The interim order earlier granted is extended till the next day. Carried out. Week after next inspection report to be filed by the next day after service of copy on the other side. Interim order earlier granted is extended till the next day. Is to put up report regarding notice issued to R4. Yes. No, now notice is still to be served, isn't it? What is the interim order? Passed by whom? Just find out. We'll have it next week. Find out. The government advocate to obtain instructions regarding interim prayer sought for. Relist the matter in the orders list on date 1st of March. The matter week after next. The interim order earlier granted is extended to the next day. Report to be filed after service of copy on the other side. Yes.
21.
Let there be this show cause notice later. Show cause notice to be produced by the next day. This is the matter next week. In direction to take any precipitative steps is extended till the next day. Now they were de-sealed it. Inspection is done, not done. Done. This is the matter. Week after next, same order. Report to be filed. Interim direction and extend to the next week. Yes.
73.
Same order. Same order. Yes. But here also a report they have not yet filed. Same order. Yes, yes. And let them, the direction that they give a copy of that inspection report to you. We're having it week after next.
75. Report is
Same order.
6.
Only on the category. Huh? Let us see. Let's see. The Form C, same order in Form C. Order earlier granted. Extended till the next date. Inspection to be made on 6th of March at 11:30 AM.
Property. Protection of complete.
Plan is for how many floors? Plan is. Have you produced copy of the plan?
Expect for the inspection and report today.
Find out, find out. Written as you. But anyhow, you produce a copy of the plan. Now they're saying there's some OS will clarify that. to produce a copy of the plan. Counsel for the petitioner submits. Construction is being carried out beyond the counsel for the petitioner submits. That construction is being carried out beyond the sanctioned construction as per the plan. Learned counsel appearing for the BBMP submits. An original suit has been filed, an injunction obtained. And suit has been filed, an order of status quo has been passed. Next. The counsel for the respondent BBMP to take necessary steps to move the trial court and point out regarding the scope of civil suits filed seeking injunction against the respondent BBMP. If such application is filed by respondent BBMP, trial court to expedite hearing of the same. Such direction is passed in light of the submission made that after obtaining injunction, the property owners continue to put up construction even beyond sanctioned limits. Insofar as R4 is concerned, the notice to be served also to the ARO BBMP, jurisdiction ARO BBMP. Now in this proceeding he is avoiding. Here he is avoiding. So let notice go through you only. Through the assistant executive engineer, jurisdiction assistant executive engineer. This would be in addition to notice as already ordered through court. Excluding alone. Page, paragraph. It should be excluding interest and penalty.
Yes, regularly paying the taxes as per the CH-8. Yeah, they have to exclude that amount and difference amount is 50%.
Where is the disputed demand?
And demand is beyond 5 years.
So what will clarify? Petitioner to pay 50% of the disputed demand of tax, excluding interest and penalty. After taking note of payments already made.
Therefore,
I'll clarify that.
Difference.
It is pointed out on behalf of the senior counsel, we have the petitioner, that there is some ambiguity in the interim order passed. Accordingly, the order is clarified as below. The direction for the petitioner to pay would require the petitioner to pay 50% of the disputed demand of tax, excluding interest and penalty. Made clear that the 50% required of disputed tax required to be paid would take note of taxes already paid. And granted. 1 week's time is granted from today for such compliance. Needless to state that tax paid, amount paid by the petitioner would be adjusted to the lawfully paid taxes. Deal is the matter week after next. Let that go on. It is clarified that
Not the tax. Beyond 5 years.
let us see, it's only that disputed tax demand. We are not saying interest or penalty. The inspection to be made as earlier directed on 27/2/2024. It is the matter week after next. Interim order earlier granted is extended to the next day. Yes. Show cause notice. Let us show cause notice to same order, Form B. The matter and the order is next week. Interim respondent BOT not to take any precipitative steps pursuant to
G.
let us C to G till the next date. More accepts notice for the
Sealed property.
seal.
Not the DCL.
What is the due that they have now raised? What is the due that they have raised? What is the
2 lakhs every year. 2 lakhs every year from 2017 to.
we will adjust it only to the finally payable amount. Make some deposit. We'll adjust the amount to finally what is determined.
Every year I paid.
But now they've sealed it on the base, at least disputed tax, some amount we must pay. That will be adjusted. Anyhow, April is coming. What is the month, what is the yearly tax you are paying?
But I'm saying, so to make sure the 48 something. Now we got I'll pay 54,150. Latest tax 52,000. Let's say 45 it's 13, you have to pay 48. Should the show cause not right now? Should the entire influence of property taxes?
Now you pay 1 lakh for the present, we'll see. We'll adjust it. What's if it is not, then it will be adjusted towards next year.
But penalty they're saying.
When you pay 1 lakh.
1 lakh something. Penalty.
Now you pay 1 lakh. No? You deposit 1 lakh. That will be deposited, adjusted towards the tax that is payable. Of the disputed tax. How much that will come up to?
Every year they will give 2 lakhs, 2 lakhs. What of people I pay every year 20%.
20%. The petitioner undertakes to pay 20% of the demand that is raised within a period of 4 weeks from today. is in light of the recording such undertaking, property to be desealed forthwith, in addition to the order. Desealed forthwith. At the week after next, made clear that the interim order and vacated if at the end of the period stipulated in the order, payment is not made. A 1 of 24 is allowed, and production of certified copy of annexure C to G is dispensed with, subject to the undertaking that the same would be filed in due course.
What they have done is, they have said that as per the review report, your property was in C zone. Therefore, you have to pay the differential. Lord, I have produced the annexure to show the Lord that the annexure young. The bank of the it falls in D zone.
Now they have taken any steps or not?
Now they have seen the property. That's what I have declared in my SAS application. And they say that the property is measured 2,800 square feet. No notice was given, and they have unilaterally said that the built-up area is 2,800 square feet, whereas it is 2,000 square feet.
You make some deposit, it will be adjusted towards.
For all these amount that they are claiming, but I mean, permitted to pay back.
Where is the demand notice? You have calculated the sum total. No, so correct. So you will pay 1 lakh within. What is the bill?
2,471 for 1670, 1780, 1890. They have to run 81,000 for 2018. So if we calculate not, we will come to 5,80,000. I will deposit 1 lakh.
Initially, inspection on 4th March 2024 at 11:30 AM. The department will not to take any specific steps pursuant to the impugned notices and demands. In light of the submission that the premises have been desealed, with evidence at annexure N, light of the interim order passed above, the respondent BBMP to deseal the premises forthwith. Petitioner to undertakes to pay sum of rupees 1 lakh in a period of 4 weeks from today. Said amount would be adjusted towards the lawfully payable property tax. The matter week after next. He accepts notice of first respondent on the correspondence 224. Office objections? Yeah. Give him a copy. Give him. You paid up to date tax. So let the show cause notice to people. Same order. At B. But in the orders list, we'll give some date next week. 29th. In the interregnum responding DPMP not to take precipitative action pursuant to annexures A to A3. To the next step. Obvious objections to be complied with forthwith. The court fee you have to pay today only.
What has happened is, but when you see a undeveloped land, you will see not only sharks, even the authorities seem to have an eye on that land. Because now, but this is second road litigation. My father has been to court for the last 40 years, from 1975. But initially, 3 years back, the immediate beginning saying, this is a lake bed, and not will excise property with 148. I have approached the honorable court, honorable I could not castigate them for exercising this power. It says you should not be acting in this manner, not quasi those proceedings. Now, with the same humor, they approach the regional commissioner at the 134 of the PDMP Act. Thinking it's a lake bed, but this is 31% road in the heart of the city. Because of the litigation I had the previous owner, it was going on for several decades, property was not developed. Now that all those litigations have got settled and I'm looking at development, but unnecessarily lots of costs with ulterior motives, some impediment or the other, we will cancel the Karnataka, this lake bed not right in the heart of the city. And about these proceedings under 134 are without jurisdiction, not impact all their cases. That this government property which is not neither in the CDP nor not in the lake. And the Kata record shown not from 1970s, the Kata is in their record. And 134, they cannot make a claim, but 134 is for claims by corporation of what property belongs to it. Admittedly, but in this case, the allegation is according to the assuming for sake of argument, it's a lake bed. But it's not their property, therefore, those proceedings are completely different. This is the only point about which is, and not based on this, I'm in my 90s now, I want to see some benefit after having solved litigations, etc., for after decades. But the corporation must, for explaining reasons.
Other ways. It's a top of the list. Take a chance, we'll have it on Friday, take a chance. Finish the matter on Friday. And you should, counsel, you should, when you say seek for adjournment, you can't say, I'm going before the commercial court, before the high court. You can't say that. You must give some other reason. Look, no, you can't tell that reason. No, I'm saying when you say something, it should not be objectively verifiable, or it must be acceptable. Or no, okay, he'll advise you. I'm not denying that. Yes. Order earlier grant is extended till the next day. That's why we used to have apprenticeship. 97, all of us are underwent 1 year of apprenticeship. When we had to wear the tie, maintain a tie. Some things you have to tell the juniors. No, he doesn't know. We can't blame him, but we should tell him. When you go there, at least when you're asking your junior to go and take time, you must say, it may be a fact, but you must tell him what is acceptable, isn't it? So that somebody must tell them. Yes. It's week after next.
82, NS for 82.
Yes, sir. At request, release the matter on date code.
Second page. Second page.
At request, release the matter week after next.
84.
Release the matter on date code.
28.
28.
85.
The matter.
I appear not in 85.
85.
I appear not in 85 for the petitioners. Matter has to be heard, my lord. I have filed my rejoinder also.
Will not
There
be
is-
possible. Will not
There
be
are-
possible.
Annex-
Yes,
Sorry.
yes.
There are a number of annexures, my lord, which have been filed with the statement of objections of the BBMP. They are not referred to in the affidavit. They are not paginated. They have to set that right, my lord, because there are a number of documents which are not there in the body of the objections at all. However, my lord, I am ready to address arguments on whatever available documents are there. What has happened in this case, my lord, is this, that the building was completed, occupancy certificate was issued, and we have substantially sold. I'm a developer, my lord. It's been sold also. There are occupants in it. All that happened, my lord, several years ago. And now, my lord, at the instance of a neighbor, the BBMP issues me a notice under 321(1), 321(1), saying violation, whether they can issue, my lord, occupancy certificates issued in the year 2012. So can they issue me a notice 10 years thereafter is the question.
Yes, for BBMP. Interim order is passed.
Yes, my lord, there is an interim order in operation. We went before the appellate tribunal, not the Karnataka appellate tribunal, and the tribunal, my lord, goes into matters which are not in the 321 notice at all.
Yes, let
That
us
is
see.
the
I'll fix
challenge.
the, yes, I'll fix the date.
Please, ma'am.
Request made on behalf of the respondent BBMP. Matter is adjourned. Lord Senior Counsel Shri S.S. Naganand admits that occupancy certificate is granted on
It is dated, my lord, 15th November 2012.
15th November 2012. And if that were to be so, question of initiating proceedings under 240 under 321 does not arise. Such power must be exercised within a reasonable period of time. A request made on behalf of the respondent. Relist the matter on date. Fourth.
Great.
Have you taken permission? Have you taken permission? Respondent number 3. File the preliminary submission, same is taken on record. Now you have to serve a copy on the petitioner. Petitioner's copy is placed on file. Yes.
We'll collect it from the registry.
Yes.
But the BBMP may have to set right its counter because there are a number of annexures which are not referred at all in it.
Respondent BBMP to rectify errors pointed out by on behalf of the petitioner found in the statement of objections.
Please.
Yes. Consider. Petitioner. In the nature of mandamus directly consider the representation at annexure E by the petitioner. It is asserted that the terms of OS 264 of 2022 it has been passed. And in terms of which Tata may be affected with respect to property number 128. Light of the limited prayers are for the respondent submits that the representation at initially to be considered and disposed of in accordance with law. It is further clarified that the petitioner is to furnish necessary documents and clarifications as may be sought for when the respondent considers the representation at annexure E. The consideration to be completed within 6 weeks, within 8 weeks. Just wait, just wait. It's coming up for the first time. Is the matter on
I am for the respondent, I
90,
Pray for some-
90.
I'm sorry, my lord.
Yes. Now, counsel appearing for the respondent submits that complete copy of petition with annexure has not been served. Petitioner to serve complete set of papers forthwith on counsel for the respondent. Yes. After next.
91. Number 91.
Objections you have filed, is it? Government? You have filed objection in this. 91. Objections to be filed by the next day. This is the matter week after next. Yes.
92.
92, I pray for some time to file my objections, my lord. It's a
Week after-
contract matter.
Yes, list week after next at request made on behalf of the respondent.
Much over.
93.
Still, week after next.
54.
This week, hmm? In this course, where is your representation? Nature? On what basis? What is the document? No, now he's seeking transfer of Kata on what sale deed or what? Then you consider the petitioner. It's not for issuance of writ in the nature of mandamus. Direct respondent number 1 to transfer Kata of the scheduled property in the name of the petitioner. Petitioner made out the representations in which it is asserted Kata with respect to the property which is subject matter of the writ petition was standing in the name of the petitioner's father, and after his death he seeks transfer of Kata to his name. It is further submitted that a decree has been obtained by him in the form of an injunction suit in OS 14 of 2017. And though the said despite such judgment and decree, wherein the property of the petitioner is described in the schedule, respondents have failed to effect kata. Light of the limited prayers of petition is disposed of, the request for kata has made to respondent number 1. Be disposed of in accordance with law. Instruct petitioner to furnish necessary documents as may be required to process the request for transfer of kata as is permissible under law. On submission of documents sought for, respondent authority, first respondent to pass appropriate orders within a period of 6 weeks thereafter. 8 weeks thereafter, all contentions are kept with. Serve copies. These are the petition to be served. Council for R5. List the matter in the week commencing from 11th of March. No, let them look into it. Let them look into it. Memo filed along with the spot inspection report. Copy of the same to be served on the other side. Served. You go through it next date, please. Relist the matter. Week after next. April. 11. Yes.
87? Yes.
Matter week after next. This is some other day. Some other day. Relist the matter. Relist the matter on
4th March.
filed. Draft issues for consideration. Same is taken on record. Serve a copy on the government agent and for BBMP. Relist the matter. This is the matter on 18th of March. In light of all pleadings having been completed, both sides to be ready. Yes. The statement of objections by the state to be put on the notice board so that any of the council who have not received obtain copies of the same. An extra copy also to be kept with the court office. Yes. Orders earlier granted are extended till the next day. Not usual. Dates will be given. Interim order, all those matters which don't reach interim order will be extended.